Right. You give him a copy of the short notes.
I already given you.
All right. List along with STREV,
100 of 2019
100 of 2019
on
26th
26th.
April. All right. Interim order to continue.
This submission item number 2.
My lord, this is a issue pertaining to unorganized laborers filed by Odisha State Legal Services.
Right, right.
My lord, they had submitted the counter. But if I had lordship's indulgence, I would like to bring out a few issues which I noticed in the counter.
If I may, my lords, there are two matters listed today. And the companion matter, my lords, is coming up on the 19th. That pertains to, my lords, building and other construction workers. So if both can be taken on 19th, because what my learned friend, if she gives the response in writing, then I'll be in a better position to take instruction and assist my lords, because
That's okay. But let it not come on the same day. The whole endeavor of your lordship was to segregate the two, because there was some confusion in the minds of the state agencies, construction and unorganized. Therefore, they were segregated. Today in the listing, it says that the other matter comes on 19th. So if your lordship, today we are discussing the unorganized workers issue. If your lordship.
You can have it on another day then.
yes, my lords,
All right. In this, you say in Petition Civil 687 of 2016, an affidavit has been filed by opposite parties 1 and 2 on 12th September. Sorry, on
24th November.
24th November 2022. Ms. Party states that she will file a note of submissions in response to the said affidavit and serve it on counsel for the state before the next date. We'll have this on 21st March.
21st March.
The other matter you say list on the date already fixed. That is 19th. Right.
Right.
Item number 3.
My lord, I appear virtually in this matter, your lordship.
Yes.
My lord, this is a issue relating to illegal cattle market, which is being run at Barikpur cattle market, your lordship. My lord, in this particular market, our volunteers, my lord, the petitioner is a organization which is looking after the welfare of the animals all across the country. It has about, say, more than 50 animal centers all across the country, and their volunteers visited this Barikpur capital market. And my lord, on visit to the market, it was observed that more than 5,000 cattle are illegally hoarded, tried cruelly with each other, and they seem to be starving from many days. And there was no provision for shades, water, fodder.
Yes.
There was no provision, your lordship, for shade, water, fodder, medical
Sir,
aid.
did you make a representation to the government? Because the
Yes,
PI rules require that.
Yes, your lordship. We made a representation to the district magistrate, your lordship. That is on page 39, your lordship, of the petition.
And Annexure 4 also. 17 June, you have repeated it.
Yes, your lordship. And we made a representation to the...
So what we'll do, sir, in the first phase, we'll ask the district magistrate to give you a hearing and
Yes,
let him address each of these issues, let him pass a reasoned order.
Yes, your lordship.
And if it still doesn't get resolved, you can always come back here, sir.
Yes, your lordship.
All right.
My lords,
My lord, only
I've
thing
just
which I
one
wish to point...
I've just one submission. I've received instruction from the IIC Soror with regard to only that Barikpur Bazaar. And my instructions are, in the meantime, the cattle market has been stopped and there is no sale or purchase of cattle
At Barikpur.
At Barikpur.
I see. Well, I'll just record that the IIC says that the Barikpur market, livestock market is stopped. All right.
Yes.
You see, this is a public interest litigation brought forth by an organization which is stated to be looking after the welfare of animals generally and cattle in particular, and old cattle in particular. Full stop. One of the concerns expressed in the petition is about the conducting of a livestock market in Baritpur, which is within the limits of the Soro police station in the Baleshwar district. Full stop. Paragraph. Since an advance copy of the petition was served on counsel for the state, he was able to obtain instructions from the inspector in charge, Soro police station, that the said Baritpur cattle market has now been
Stop.
Stop. and is no longer held there. Full stop. The said statement is taken on record. Paragraph. As regards the other grievances expressed in the petition, it appears that the petitioner had made representations to the district magistrate Baleshwar on 17 June 2022. Is it only this, or generally there are other livestock markets being held?
That I need to check, your lordship, but the volunteers visited this market. There must be other markets also which are being
No,
illegally
if you
run.
want, then we'll, instead of this representation, we permit you to make a representation afresh if there are any other issues.
Yes, your lordship. And your
All right.
lordship,
If
I mean,
there are-
we may be permitted to make representation to the government.
Yeah, if you
government.
find something else needs to be, yeah.
Yes, my
yeah,
lord, I
since-
just wish to point out that we had moved Honorable Meghalaya High Court on similar issue,
I see.
and there, your lordship, the Honorable Meghalaya High Court passed a very detailed order with respect to not only, because there also we approached for one particular market where we approached illegality, but the Honorable High Court passed an order which was pervasive for the across the state, and to ensure that all across the state the markets are being run in accordance with the prevention of cruelty to animal regulation of livestock market rules 2017.
No, which is why I'm saying if you find that apart from this Baritpur, there are other markets, you make a representation and then we'll ask them to look into it.
Yes, your lordship, my humble submission, your lordship, is that if your lordship directs the government of Odisha to take cognizance of this illegality and take care of the, if any illegal market is there all across the state, I mean, that will help the animals a lot, your lordship. Because the animals cannot come, and there is a limitation.
So that general direction is neither here nor there. You'll be back in court saying there's contempt of the court and all that. It's better that you draw their attention to specific instances.
No, your lordship, we don't want it to be adversarial litigation.
No, not for adversarial. It should be effective. You see, if we just generally pass orders, it may not be effective. That's all.
Yes.
You'd say if there are any other grievances that the petitioner has in relation to any specific instances of violation of the prevention of cruelty to animals, bracket regulation of livestock markets, bracket rules 2017, it will be open to the petitioner to make a fresh representation to the concerned authorities, and after following up on such representation, to seek appropriate remedies in accordance with law. The petition is disposed of in the above terms.
Grateful.
Right.
Grateful.
Item number 4.
No, please. My lord, petition challenge illegal and arbitrary action of the opposite party number 4, who has not been taken any action against the OP number 5, who has encroached the government gochor landmine. In this regard, the petitioner filed a representation before OP number 2, Collector Bhadrak. The Collector Bhadrak sent to the representation to the OP number 4, Tahsildar Basdepur. My lord, now the representation is pending before the Tahsildar Basdepur. Let be direction given to
All right. The petitioner's representation, bracket annex 3, which was sent by the collector to the Tahsildar Basdepur, will be examined by the Tahsildar Basdepur, and after notice to the petitioner and opposite party number 5, and after giving them a hearing, a reasoned order should be passed thereon by the Tahsildar Basdepur on or before 17th April 2023, and be communicated to the parties within a week thereafter. The court clarifies it has not expressed any view of the matter.
Oh. Item number 5.
My lord, in item number 5, my lord, my application for refund has been rejected by the adjudicating authority, which had been offered by the Commission of Appeal, your lordship. And with the observation that, my lords, Sextat being the creature of the statute, your lordship, being a quasi-judicial authority, the principles of equity cannot be decided with them. It is only the read court can entertain the appeal petition. Page 51 of the impugned order, your lordship. Kindly have a glance to page
All right,
51.
anyway, notice. Who Mr. Badi accepts notice for?
I'm appearing for 2, 3, and 4.
Yes, my lord. Yeah, Mr. Padi for 1 and he appears for 2, 3, and 4.
No, I'm for the opposite party, my state.
Some other matter. Replies be filed within 8 weeks, rejoined for the next date.
Obliged, my lord.
6th July.
Item number 6.
May I please, Lordships? Lordships, inadvertently, I have not served a copy on the state. Just now, I served a copy of the writ petition to State GST Council, Lordships.
What's the matter about?
The matter is regarding the levy of GST on royalty, Lordships.
But only a notice has been issued or
No, your Lordships.
demand notice?
I have challenged the demand.
Similar
Yes, yes. There is a judgment.
It has been covered by.
Yes.
You can't have a. Correct.
But in this,
We'll pass similar order because here again you're not replied to the show cause.
no. In this case, I have replied, but I have not annexed. In the meantime, during the pendence of this writ application, I have replied to the authority and saying that the royalty what I have paid already, that is not actually liability. The liability is not upon me because I have not operated the sand quarry at that time. So this is the difference. That is why
No, you file a supplementary reply enclosing copy of this judgment.
Yes, Lordships.
All right.
Yes.
You see, this is once appears on advance notice for the opposite parties. 2 to 6. No, 2 to 5. Full stop. It is not in dispute that the issue involved in the present petition, namely whether single court's royalty court is amenable tax under the GST regime stands covered by the judgment of this court dated 26 July 2022 in writ petition civil 8492 of 2022 bracket Hitambani Mishra versus Union of India bracket. While declining to interfere with the demand come show cause notice issued in that case, the court permitted the petitioner to file a reply objection thereto, even while examining the legal position paragraph. Consequently, petitioner informs the court that as far as the impugned show cause notice dated 24th February 2022 in the present case is concerned, during the pendency of the writ petition. A reply has been filed by the petitioner therefore. Full stop. However, the petitioner had no occasion to enclose a copy of the above judgment in Vitambari Mishra as part of the reply. Full stop. Paragraph. In that view of the matter, the court permits the petitioner to file a supplementary reply to the impugned SCN, enclosing a copy of the above judgment and making any further submissions in relation thereto, not later than 20th February 2023. Full stop. The order on the said SCN will be passed after taking into account the said additional reply. No further directions are called for. Depending on the order passed on the SCN, it will always be open to the petitioner to seek appropriate remedies in accordance with law.
But my friend for the state GST
Yes.
is appearing for 2, 4, and 5. I'm appearing for respondent number 3. He's appearing for respondents 2, 4, and 5.
All right. So
I'm for the central GST, my lords.
all right. All right.
Item number 7.
May I please the lordship? Your lordship, the petitioner has challenged the order of the first appellate authority. So yeah, under GST Act, and your lordship, the petitioner has already paid the entire tax amount and penalty.
Since no second appellate authority has been constituted as yet, court is constrained to entertain the petition. The next paragraph, notice he accepts notice on behalf of opposite parties Reply be filed within 8 weeks, rejoined for the next day. Paragraph. The constable of the petitioner informs the court that the entire tax and penalty has already been paid, which will be obviously subject to the outcome of the present petition. List on 12th July.
Grateful, your lordship.
Item number 8.
My lord, in item number 8, your lordship, I have effected sale in the course of import to the territory of India, your lordships, under section 5(2) of the CST Act, your lordships. When the statute does not request Form H, your lordships, I have been demanded for non-submission of Form H, your lordships. My application for rectification defect also been denied as because I have not filed the annexure to table D, the part 3, your lordship. At page 37, your lordships, of my paperwork, your lordship, my read petition, your lordships, I have filed the table 3 of the annexure, that is a sale in the course of import to the territory of India, your lordships. This has not been verified, my lords. That means that there is a huge demand has been raised against me without verifying the fact, your lordships.
No, this is an order passed by the
By the assessing authority, by the sales tax officer, my lords.
issue notice. Notice, he accepts notice for opposite parties. And you want to file a reply or you take time for instruction? It's only about rectification of the
My lord, he has not filed those documents before the assessing authority so that he has rejected his.
It is available in the portal, my lord, page 37, my lords. It is available in the portal, page 37, my lord.
Instructions may be called for it.
All right.
For imports, H form, I think it's not necessary. For export only, penultimate export is only.
The annexure is there.
But he has imported.
I will take instructions for it.
All right. 6 type of instructions. List on. March.
Obliged, madam. My lord, I may be protected, my lord.
All right. Till the next date, no coercive steps shall be taken against it.
Grateful, my lord.
Item number 9.
May please your lordship, the prosecution has been initiated against the shareholder of the company. Now the 2 other shareholders are outside the state. So against the prosecution, now petition is pending in compliance to the issue of a notice made by the Commissioner TDS, let the Commissioner first dispose of the matter so that I can be able to proceed all this, because the opportunity of hearing was not given to me at all.
So,
Because
but
I
what
have-
is this prayer clause? Just read the prayer clause. I don't know. It's like two grounds. It's not like reading like a prayer clause at all. No details, nothing given.
Adequate opportunity to know about the matter since the petitioner has already resigned. If
No,
this
no, all these are grounds. I've never read a prayer clause like this. Have you read a prayer clause like this? It's leading like grounds of.
And two directors outside.
This is all prayer clause which you're reading.
Yes.
Will a prayer clause read like this?
I will make it modified.
Counsel of the petitioner seeks leave to withdraw the present petition with liberty to file a proper petition with proper prayers in accordance with law. Disposed of is withdrawn with liberty is break. All right.
Item number 10.
So item 10 and 11, Lords, have been connected with item 61 yesterday, Lords. So it's gone to 28th February.
All right.
Connected with WPC 25400 of 2022. It was yesterday.
List on 28th February 25400
of 2020.
Of 2022. All right.
Great.
All right.
Item number 12. Supplementary list item 12.
Unappeased dismissed clause.
Item 13.
Same.
Item number 14.
Item number 13, Lord. So I request your Lordship to pass a mirror order. There are already orders involving identical point.
All right. All right. 23rd February. All right.
Item 15.
15 is covered actually by your Lordships, that earlier order passed in Harapriya Bisoy's case minutes. I'm passing on the directly covered and in issue also.
No, but no notice has gone in this.
No, we had filed a review because these two judgments were standing in the way because the Honorable Court earlier had held in 92 and 93 that member board revenue had no power. Thereafter managed that Harapriya Bisoy where they again relied up.
It is now not in dispute that the orders under review cannot stand in view of the judgment of the Supreme Court in State of Orissa versus Haripriya Bisoy, AR 2009 SC 2991.
No, engaged. GA department.
Accordingly,
Obliged.
the review petitions are allowed. And the judgment dated 2nd November 1992 in OJC number 2057 of 1992 and 2063 of 1992 is hereby reviewed and recalled. Review petitions are allowed and disposed of. Is allowed, accordingly allowed.
Item 16.
Grateful.
Item number 16.
None appears dismissed.
Item number 17.
Again, none appears dismissed.
Item number 18.
Flag 10 mallet or modification of mallet order filed by the opposite party number 2 to 5 mallet. Well, the order was passed mallet saying that the judgment cannot be a basis for a suit for damage. But actually, mallet inadvertently, while the order was passed, the opposite parties could not appear in the case mallet to say and clarify regarding the suit for damage is filed prior to the order passed by this honorable court.
It's all happened 12 years ago, sir.
Latest in what information I had got,
that now the suit is no more than it has been.
There is a CMA is filed for restoration of the case that is submitting that is dismissed for default.
That's
Not
all you
dismissed
see.
for
You don't
default.
have to. You see, there's no merit in this application. It is disposed of as such. All right.
The suit stand rejected. That's the certified copy of the.
It's all right, sir. There's no merit in this application. It is disposed of as such. Right.
Item 19.
18 April is noted.
All right. Just the MC number, not the main.
Item number 19.
None appears dismissed.
Item number 20.
You're in 19.
My lord.
Ah,
My lord, the CELTAS revision application has filed by the petitioner. Substantial question of law arises out of the impugned.
you've not filed application for limitation.
Limitation application I will file. Already
2
filed.
days. All right. What's
My
the what is substantive question of law?
My lord, the substantial question of law arises only as a matter reopening of assessment under section 43, my lord, prior to amendment, my lord. Past, this is a tax period from 1/4/2008 to 31st March 2008.
Report anything at all.
Assessment has been completed under section 43, my lord. It is covered by
The revision petition is not scanned. Just see this. This is an appealable order.
my lord, it's a
Oh, it says-
reopening of assessment.
Sorry. You say admit the following questions of law.
Copy not being solved.
Consideration.
In course of the day, I will serve the
Assessment order
copy.
dated. The date of the assessment order. Assessment order dated. Very badly drafted, sir. 23rd October
My lord,
2013, as affirmed by the Orissa Sales Tax Tribunal by the order dated 29 September. No, as affirmed by the Joint Commission of Sales Tax by the order dated 31st March 2015, and the Orissa Sales Tax Tribunal by the order dated 29 September 2016 is sustainable in terms. The original records be kept ready for perusal on the next date. List on
my lord, what?
17th July.
17th July, admitted the question of law. Records are called for.
Call for. Copy will serve on the statement.
Item number 20.
Yes, small defects are there, but your lordship now paperless court. So therefore, I am complying. A second copy of the brief pillars along with a memo.
33 days delay.
And second defect is provision. It's a formatted application. Your lordship knows. And I have also mentioned the provision under which the revision is filed in the first page of the application itself. And that is a delay, my lord, 33 days. If your lordship please to condone.
Yeah, delays condoned, that exemption is allowed. So audit visit report.
My lord, so far as the question is concerned, that is covered by a judgment of this honorable court in general status case, my lords. Yes, I am giving a copy to lordship.
Copy has not been solved, my lord.
Copy have given. I have already given. So this judgment takes care of the question, my lords, whether there can be levy of penalty under section 12(3)(g) for non-submission of declaration form C or H, my lords. And your lordship, my lords, has referred to circular of the commissioner, in which, my lords, commissioner has said that this absence of relying upon so many judgments, it's a very descriptive circular, referring to various judgments of different High Court and Supreme Court, said that so far as scope of 12(3)(g) is concerned, my lords, non-submission of form will not enter penal action, my lords. Yes, there is other part is also, my lords. If your lordship will see this is one, my lords. Yes, may I place for the additional question also why that is necessary? Because the Honorable Tribunal has allowed so far as the payment, additional payment I have made, and accordingly reduce the demand. Certain payments are made, but that has not been, my lords, taken care of, and now that is considered. Second issue that arises, my lords, there is also some dispute involves because of, my lords, reduced grant of ITC. My lords, I have claimed more, they have allowed less. Whether reduced, my lords, amount of ITC will entail penalty under 12(3)(g, that my lords, because unlike others, 45%.
Once we hold that 12(3)(g not attracted, then there is non-submission.
If this takes care of, my lords, I have. Absolutely.
Is this question relevant?
This input tax credit, my lords. The other issue, reduced input tax credit, that is allowed. I have claimed more, they have allowed less. So far as the reduced, because this is 12(3)(g, your lordship will find it's contingent. It refers to 12(3)(e) and F, my lords. If those contingencies are satisfied, then only 12(3)(g. And these forms are not covered. So also input tax credit, to my humble submission, that is also not covered under 12(3)(e) and F, my lords.
Right. Is I admit, is penalty leviable on the petitioner either on the ground of non-submission of Form H, is it? Forms C and F.
C and F, my lords.
C and F, or in cases of reduced input tax credit, under section under Rule 12 bracket 3 bracket small g of the CST bracket O rules. Question mark. The original record we kept ready for perusal. List on 19th July.
My lord.
Item number 21.
So may I pay for interim
things happening, sir?
My
find it long ago, nothing's happened.
My notice me on stay.
Okay. No, there's no application for stay.
My that is, my lord. That is one, my lord. That is IA
there are two IAs.
My lord. IA number 90. Sorry, not
223. You say in IA 223 of 2018 notice. All right.
Diploma.
All right.
Item 21.
Item 21, your lordship, there are some defects. 1 week time may be allowed.
Last opportunity to remove defects on or before. You say no, list on. List on. February. No, 21st February. Defects be removed in the meanwhile. Right.
Obliged.
Item number 22.
May I please, your lordships? Your lordships, in this matter, Honorable Justice Raman was the conducting counsel in the second appeal, your lordship.
All right. List before bench of which Justice Raman is not a member. On 10th February, defects be removed in the meanwhile.
Yes, obliged, your lordship.
Item number 23.
May I please? The opposite party, this is a petition under public interest litigation, my lord. The opposite party number 5, claiming to be the hereditary trustee, pursuant to the order passed by the endowment commissioner, my lord, indiscriminately she is selling the property of the DT, my lord. So Annexure 7 is the order basing on which he is claiming her right. But Annexure 7 is the order that is basing on the decree passed by the civil court, my lord. But the decree that has lost its force, my lord, your lordship may turn to page 53, my lord. Initially, the ex parte decree was passed. Subsequently, my lord, that ex parte decree that was set aside. Annexure 3, Annexure page 53, my lord, on 12/7/2006, my lord. That ex parte decree was set aside. Subsequently, my lord, the plaintiff did not take any step. Subsequently, my lord, on 4/11/2008, the suit was dismissed for default. So the decree has no force at all. On the basis of that decree, my lord, claiming to be the declaration by the civil court, she has got an order, Annexure 7, my lord. She has not disclosed anything about that decree, my lord. Rather, she has disclosed before the commissioner about the decree, ex parte decree passed. Subsequently, that has lost its force. It has been set aside. On the basis of that decree, my lord, that order, my Annexure 7, she has been declared as hereditary trustee.
Why haven't you moved the commissioner first?
Either they have to move the commissioner or they have to challenge this Annexure 7. Because as long as this Annexure 7 stands, he has got a valid ground to say that the decree basing on which the commissioner has passed the order, that decree is no more in force. But this thing has to be adjudicated by the appropriate authority, not in a PIL. That is my responsibility. Because it is under statute, the order was passed under a particular statute.
Yes, your lordship may give me liberty.
Petitioner seeks leave to withdraw this petition with liberty to approach the appropriate authority under the OHRE Act in the first instance, and thereafter seek appropriate remedies in accordance with
in some cases, my lord, your lordship has also entertained the writ applications, and your lordship, no, my lord, of this property, my lord.
Whatever.
Of this property, my lord, your lordship has entertained writ application, and your lordship has directed the state to take instruction as to what is the value of the property and how it has been sold.
So we'll anyway deal with that in those matters. All right.
Item number 24.
Obligement.
This petition is not a nature of PIL, my lord. However, my lord, the court feels that it is a PIL for which, my lord, the order was passed. My grievance before your lordship, my lord, the opposite party number 4, who has unauthorized constructed a house over a public road, my lord, for which, my lord, an unauthorized construction case was filed and the eviction and demolition order was passed, which was challenged in appeal. Appeal was also dismissed, my lord. My prayer before your lordship, my lord, that those orders for demolition, they have not carried out, for which, my lord, I have, my lord,
made a representation.
Petition Annexure 10, my lord.
Annexure 10.
Yeah. You say the petitioner's representation dated 12th October 2022 will be examined by the chairman CDA.
Enforcement officer CDA, my lord.
By the enforcement officer, Cuttack Development CDA, and after notice to the petitioner, as well as opposite party number 4, and giving them a hearing, the reasoned order should be passed not later than 27th April, 24th April 2023. The order shall be communicated to the parties within a week thereafter. The court clarifies it is not expressed any view on the matter.
Item number 25.
May I please, lordship? Lordship, this is a PIL case, lordship. Lordship, the opposite party hastily, in observing the Chaiti festival without following the lordship district cultural committee, which is mentioned in the district council of cultural rules, lordship. Lordship, kindly glance at the annexure 2, that is page number 11, lordship.
Anyway, you have a representation. You see the petitioner's representation.
Annexure 5 at page 14.
Yeah, 22nd December 2022. Shall be examined by the collector, Rayagada. And after notice to the petitioners and giving them a hearing, a reasoned order shall be passed thereon not later than 20th February 2023. And will stop the order be made available to the petitioner within a week thereafter. The court clarifies it is not expressed in the matter.
Item number 26.
One pardon, lordship. Festival will be held on 18th January, lordship.
Come the last minute, then what do you do? You come in the last minute.
Lordship, on that grievance, Lordship kindly consider my.
On or before, I don't know. We're already on 12th.
18th January is the next week, Wednesday. It is not possible at all.
Come too late.
Lordship, kindly consider my representation, which is.
I know, but how will it decide so soon?
Because it is Rayagada.
And at this
all
stage,
preparations must have been finished.
For
the next year, she may take a chance for the next year.
You say, take off this order. You say, considering that the Chaiti festival is to be held on the 18th January 2023, it's not possible for this court at this last minute to direct a reconstitution of the committee for conducting the festival, leaving it open to the petitioner to agitate its grievance, if any, for the next festival. The petition is disposed of.
Lordship, I have already submitted my representation.
That was long ago. You have not followed up. You can't come 1 week, not even 1 week, 5 days before the festival. Right.
Lordship, kindly just consider my grievance and nothing else.
Not for this festival. It will be for the later. Right.
Item number 26.
None appears for the petition.
Item number 27.
May I please, Your Lordship, the order of the commissioner in this case, and at page 24, Annex 4, that has not been carried out for releasing of the gold ornaments, which were the order passed by this honorable court to release the ornaments on the basis of the.
So that you should have filed a contempt. Can't file, keep filing writ petitions like this. You can't file writ petitions again and again, sir.
Lordship, earlier order, we have filed an extension petition to give some time to dispose of, because there is legal error issues involved in this case earlier. So
Where is your IA for extension of time?
Lord, I have filed the IA in 21/6/2021.
No, where?
Because
earlier, Lord, what he is challenging.
No,
earlier,
there's another writ petition, 535.
Yes,
Maybe
that
you filed the IA in that.
Yes, but he is saying that earlier order has not been complied with.
No,
Therefore, he filed a
anyway,
second.
you say the council, the department states that the department has already filed IA number.
IA number 8340 of 2021.
8340.
8340 of 2021.
Of 2021 in writ petition civil 535 2020.
Yes, dispose of on 3
seeking extension of time to complete the exercise. In terms of the order passed with this court in that writ petition on 16 September. No. 3 to 3rd February 2020. Paragraph. In that view of the matter, the present writ petition is not being entertained. Would stop. Since the petition, particularly since the petitioner would anyway be heard in the aforementioned IA. The petition is disposed of.
Item 28.
My lord, 28 permitted to withdraw with a liberty to file a better application, my lord.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file a better petition in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item number 29.
May I please, your lordship? My lord, your lordship may kindly see Annex 2. This form of the revisional order passed by the additional commissioner of sales tax appeal, but according to the delegation of power at page 16, my lord. Your lordship may kindly see revisional power of the commissioner has to be exercised by the additional commissioner of a range. So the form of the revisional order is without jurisdiction, and the commissioner has upheld the same. Commissioner has upheld the same at page 29, my lord.
Why are you filing? Because it's
my lord.
No. Because it's a revisional order. Right? Commissioners is a revision order.
Commissioner is appellate authority, my lord.
So now you can't file it. I know, similar to that. And against that only writ petition. All right. It's a notice, he accepts notice for opposite parties. And states that he'll file a reply within 8 weeks, result of the next date. List on 17 July. Till then, no coercive steps shall be. No coercive step taken against petitioner.
Obligement.
Application for exemption is allowed.
Item number 30.
My lord, 30 is Tran 1 matter. I have appealed as per the order of the Honorable Supreme Court.
Yes, my lord. All right. The short prayer in the present petition is that the petitioner should be permitted to file the revised TRAN-1 either electronically or manually. Since the delay in filing it earlier was on account of the COVID-19 pandemic. Paragraph. Following the judgment of the Supreme Court in Union of India versus Philco Trade Center Private Limited, 2022 Live Law, bracket SC, bracket 28. This court sets aside the letter dated 3rd June 2020 of the Commissioner of CT and GST, bracket IT, as well as the decision of the High Level Committee, bracket IT-GRC, bracket Annexure 9. And issues the following directions. Take from 1 to 6. The writ petition is
Party 1 and 2, others are this council.
I am after party
Party
for
one and
number
two.
3. Opposite party number 3.
Right? So,
3 to 5 there. Sir, 3 to only 3 will appear. State will appear for 5.
all right.
Item 31.
My lord, item 31, I pray for 1 week time to remove the defects.
List on in 31, you see list on 21st February, defects be removed in the memo.
Deep level errors.
Item number 32.
May I please your lordships? Your lordships, this matter pertains to condonation of delay, which your lordship has passed an order yesterday in WPC number 36958 of 2022. I humbly submit to pass a similar order in this.
My lord, page 4 of the petition, my lord. Para 4. He has received the appeal order on 7/2/2020, which is prior to that.
The same condoning delay only.
My lord, he has received the appeal order prior to the.
Yes.
But
COVID, what is the period for further proceedings?
90 days.
90 days. So by then COVID has come.
That's
so 10/1/2022, Supreme Court, Honorable Supreme Court has said.
Yeah. See, in view of the order dated 10 January 2022, Supreme Court of India, in suo motu writ petition civil 3 of 2020, the impugned order dated 9 September 2022 of the Orissa Sales Tax Tribunal, Cuttack, dismissing SA number 26/ET of 2022 on the ground of delay is hereby set aside. The delay in filing the appeal will be about appeal before the tribunal is hereby declared to be condoned. And SA number 26/ET of 2022 is restored to the file of the tribunal, where it will be listed for directions on 1st March 2023, on which date the petitioner will appear through an authorized representative. The tribunal is requested to proceed with the appeal on merits and dispose it of in accordance with law within a further period of 4 months. That's the only prayer. Yes, the petition is disposed of.
Highly grateful, yours.
All right.
Item number 33.
33 minutes. The only defect is copy not served. Just now I am serving the copy. May I pray minutes? Can it be taken up next week minutes? Any day?
All right.
Attachment is there minutes.
At the request of counsel, the petitioner list on 17 January.
Oh, well.
Item 34.
So item 34 and 35 similar matters. A small defect in 34 minutes, defect number 13 not properly indexed, and 35 minutes the subject code is not correct or incomplete. Not furnished, not oblique incorrect. Yes, sir. That may kindly be.
What's the matter about?
Matter minutes. If my lords may kindly remember, your lordship in the case of Joybalaji Jyoti Industries case have decided that minutes, if any information is there in public domain minutes, that will not constitute suppression to invoke extended period of limitation minutes. Here what has happened, the appropriate course of action for the proper officer is to initiate proceeding 73. Because the day he wanted to initiate proceeding, 3 years have expired. Your lordship knows per 73, limitation is 3 years minutes. And by annexure minutes, 5 and 6 minutes, 12/5/2022. Because 3 months expired, he invoked 74. And there is a judgment under section 75(2) of the OGS CGS Act says that if your lordship is of the opinion that the recourse is 73, and if your lordship will direct, then the limitation can be extended by two more years from the date of your lordship's order. And that is also fortified by a circular of CBC I am giving to lordship minutes. By virtue of that circular, it also says that 2 years minutes. Because earlier this was not there, and now after 75(2), CBI also has clarified that once your lordship minutes holds that appropriate course of action is 73 or 74, then 2 years can be reckoned from the date of my lord's order. Now, if your lordship permit me, why 73, why not 74? I will take my lord's attention to only 2 pages minutes.
No, wait, anyway, notice is to go in this.
Minus.
You say notice, he accepts notice on behalf of? Only, so tell us which opposite parties you'll take notice for.
So, opposite party, I will take
2, 3 and 4.
2, 3 and 4. Yes.
Who will appear for 1?
1 is also me.
All right, 1 to 4, notice to 5. Tracking report will be placed on record. Replies within 8 weeks, reserved for the next date. List on 15th May, 15 May. No course of action be taken till then.
Deeply obliged.
5 is
both matters.
5 is a private.
5 I will take my register post.
In the second place.
Both matters.
Both matters same.
In the second place,
The second matter, OP number 4, first matter, private OP 5.
That's the second matter 4, same order.
Deeply obliged.
Item 36.
None appears dismissed.
37.
Same order.
Item 38.
My lord, in item number 38, though there are some defects, my lord, but it can be disposed of, my lord. Petitioner grievances collector is not passing any order on the application of the petitioner for surrender of branch shop, my lord. The application is pending under annexure 1. My lord, previously this honorable court has passed an order, my lord. My lord, at page 5 of the writ petition, it has been categorically mentioned the branch of which I intend to surrender.
So this date will make it as 20th March 23.
My lord, in the
surrendering license of 4 branch shops here, what is it?
My lord, in this case, the petitioner was intending to surrender 4 branch shop in the
4 branch shop.
Branch shops.
Yes, my lord.
Name same.
My lord, here at page writ petition page 5, it has been categorically mentioned the number of branch shop which I intend to surrender.
For different branch.
Actually, my lord, what usually happened for surrendering a shop, you have to clear all the outstanding dues, then only. That is why. So subject to
I will.
compliance of
That is
all,
what I have written in my application even.
subject to compliance of rules.
No, I just want to know, are these 4 branch shops attached to the Kunta out still or something else?
Main shop is Kunta out still. There are branch shops. So
Yes, my lord, yes.
This para 2 identical in your case also?
No, my lord.
that is to be.
The name of the branch shop has to be changed.
What is it?
It is there in page 5, my lord. In the writ petition, my lord. Page 5, para 8.
So tell the name.
In respect of Rogoda OS main shop, the number of branch shop which I intend to surrender is Arahi and Karla Fulia. In respect of Sorupa Villa OS main shop, the branch shop which I intend to surrender is Fulbani, Palbuni and Madhuban. And in respect of Bethnoti OS main shop, these two Khadisol and Bhurkhandi branch shop I intend to surrender. In my prayer even I have written that, my lord. Good.
Swarup Villa is not involved. You're not interested in Swarup Villa.
Yes, my lord. Swarup Villa
and Bethnoti.
Bethnoti. These are the main shops, but I intend to surrender the branch shop attached to the main shop. There is a column.
This for the excise year, that same 21-22?
21-22, because I had applied for 21-22.
The consideration money for the afford has payable up to stands
to
paid.
31st of March 22.
My lord, may write is subject to clearance of all excise dues.
Up to, because I had applied on the year 21-22, my lord. So
that
they have not passed any order. They are sitting.
Collector will take care of all these things. Your lordship may subject to compliance of law and clear deposit of
That's
law.
obvious. But about deposit, let them order him to deposit. It's part of the order.
Yes.
Right. Yes.
Item number 39.
Here is a case, Lord, where I had applied for odd shop. The reports and the inquiries which were made, they all were in my support. The public also gave a representation that they should be opened because bootlegging is going on there, so regular shop should be opened. But this was rejected by the collector. I went up in appeal to the commissioner. Your lordship may kindly see Annexure 7. The excise commissioner, the appellate authority, by order dated 11/5/2022, just is a short order, Lord. I'm just placing for your lordship's kind consideration. The appellant has filed the present appeal assailing the rejection of the proposal for grant of license with respect to IMFL restaurant so-and-so by respondent number 1, Collector Khurda, for violation of Rule 26 of Orissa Excise Rules. The appellant has specifically prayed for considering his appeal as the respondent has rejected his application without considering the fact that within 5 kilometers radius, the proposed site, there is no liquor shop. The area is like vacuum and there is high demand for consumption of liquor. Though there is some violation of Rule 26, government has the power to relax the public and the public have given in writing for opening up an on shop. The appellant and superintendent of excise were noticed and heard so on shop site is the vacuum area and there is no liquor shop within 5 kilometers radius. There is high demand in consideration to huge population residing in the area. He has set up a restaurant investing high.
So do you want to file a rejoinder or there's a counter which you're reading?
Yes, Lord.
Do you want to file a rejoinder?
Lord,
because how do we go behind this? What whether there's a demand or no demand, we have no means of finding out.
No, what I am saying, Lord, the rejection order by the state government is based on the collector's opinion. But after the collector has passed the order, the excise commissioner has passed 2 orders annulling that collector's order and saying that has not been considered by the state government.
My lords may take page 25, my lords, which is dated Annexure 9, which is dated 20th of July 2022.
Yes.
If I may read, I am to inform you that the collector has been pleased to regret your proposal for grant of IMFL restaurant shop in the name and style so and so, as there is a scheduled caste basti which is located within a distance of 200 meters attracting Rule 26B of Odisha Excise Rule 2017. Then my lords may take the impugned order which is at Annexure 1, which is page 11, which is 28/7/2022. So this was the last order. And this is, my lords, after the excise commissioner asked the collector to revisit. And thereafter, my lords, he has revisited. And then, my lords, the state government has taken a decision. I'm directed to invite a reference to your letter number so and so on subject cited above, and to say that the government, after careful consideration, has been pleased to reject the proposal regarding grant of a new IMFL on-shop license in favor of so and so over plot this. So, the excise commissioner's observations and the collector's rejection based on Rule 26B, and unless, my lords, the government wants to relax the Rule 26B, my lords, it cannot be forced, and the government has considered it, and it is the final authority.
My only submission is that the commissioner has addressed himself to this issue and has recommended.
But actually, if it is within 200 meters, then how do you?
The government has the power.
Why should it? Why should it?
The government has the power to.
Merely because it has the power. What is so special in your case? It should
because of bootlegging. The commissioner says the people of the area are depending on bootleggers.
No.
So that is what the
That's a separate issue, sir. That's a separate issue.
Page Annexure 8, if your lordship kindly says, he has given a reasoned order.
Yes.
And that has not been considered. But what I pray, my lord, let him reconsider on the basis of this.
Why should it? Factually, it will not change. The location will not change.
No. Whether to relax or not.
No.
That they have not
decided. If you want to apply for some other location, you go ahead and apply.
No.
But this location, you cannot insist the government should relax the norm.
What your lordship is saying is correct. That government has to take a decision that will not relax.
They haven't, sir. That is why they have rejected.
No, they have not. My humble submission is they have not addressed to that point.
No. You say the Mr. Ramakant Mohanty, senior counsel petitioner, assails the impugned order dated 28 July 2022 of the Excise Department, whereby the proposal for grant of a new IMFL on-shop license in favor of the present petitioner at Karavel Nagar was rejected. Paragraph. Then, in the counterfeit filed by the opposite parties, it is explained that there was an objection with regard to the opening of a new IMFL on-shop on the ground of inhabitation of persons belonging to the scheduled castes. Within 300 meters, is it? No.
300.
No, within 200 meters
Within 200.
was this site. So paragraph counsel for the Mr. Mohanty states that the government should be asked to relax the norm as there was great demand in the area, and the non-opening of a formally licensed IMFL shop would address the issue of bootlegging in the
That
area.
is the report of the Excise Commission.
Paragraph, the court is not convinced that there should be any special dispensation in favor of the petitioner by asking the government to relax the rules in the above circumstances. Full stop. The court is not persuaded that the petitioner's case is one where the power of relaxation should be exercised by the state government. Full stop. Consequently, the court is unable to find any error having been committed. In the rejection of the petitioner's prayer for an on-shop license. The petition is accordingly dismissed.
Item number 40.
May I please your lordship? My lord, the OP number 5, we had submitted an application for on-shop license. There was a public notice. In response to public notice, there was objection was raised from different quarters. Finally, government was pleased to reject this same. Being aggrieved, he approached this honorable court. My lord, disposed of that matter, that is Annexure 9, page 34. While disposing of the case, let me complete.
Just 1 minute. But I have instruction to appear for OP number 5.
Yes,
because pursuant to the lordship's order, the direction this order has been, impugned order has been passed.
Yes, my lord. Just I would like to show, my
lord. Be given a copy of that because today I filed caveat.
Oh, I see.
My lord, while disposing of
be served on Mr. Arun Kumar Patra, whose entered appearance on behalf of opposite party number 5.
My lord, while disposing, my lord was pleased to direct the government to reconsider the matter. Then the Law and Secretary, Excise Department also intimated me to appear and participate in the hearing. On 9th December, I participated because I was arraigned as OP number 5 in the writ petition filed by my lord and brother. Then, my lord, I raised a pertinent question. The applicant, he doesn't have the valid food license. And the shop was never made functional at any other time or at the time of submission of application. Two pertinent questions I had raised. That has been never considered. Lordship may see the
accepted by the.
No, that was asked by me.
Lordship may see the 1 second is a non-speaking order.
All right. So notice he accepts.
He doesn't have full license. That is the
Mr. Arun Patra for opposite party number 5 replies we filed within 8 weeks, rejoined for the next date. List on.
Miss case I filed, my lord.
All right. Notice on that as well.
Yes, my lord. Lordship may fix a date so that Lordship may, one thing I would like to submit, whether he is having full license or not.
Yes, that
is the Lordship may see the Annexure 5. It was valid till May 2022. Thereafter, he has never renewed.
All right. It's renewed, already filed in the government. You don't know. I was asked and I have already filed.
11th May.
Item number 41.
Item number 41.
Copy baby shop.
Yes, in course of the I saw.
Your Lordship, I'm praying for a Passover, Your Lordship, item number 41.
Awesome.
Item 42.
In that case, the appropriate court will be filed in course of the day, my lord. And there is a defect, there is a delay of 150 days.
Tell us the delay, sir.
150 days delay. May I pray the notice be issued for the delay, sir?
No. You have to convince us, sir.
Beg your pardon?
You have to first convince us about the delay.
Yes, madam. Because he was ill, suffering from gastritis.
Gastritis and all is not a ground.
That is the only ground being advised.
Yeah. The miss case number 573. Sorry, miss case number 572 of 2014. There is a delay of 158 days in filing the present appeal. The reasons given in the application are neither convincing nor satisfactory. The court is not therefore persuaded that the delay should be condoned. Accordingly, miss case number 572 of 2014 is dismissed. Consequently, the writ appeal is dismissed.
And my lord, there is a violation of the principle, the fundamental principle by the trial court below, as well as being confirmed by the honorable single judge.
All right.
Item 43.
None appeals.
No instruction.
No instructions dismissed.
Item 44.
None appeals dismissed.
Item number 45.
No instruction. With liberty. No instruction with liberty.
What liberty, sir? Writ appeal, no liberty. No instructions dismissed.
Item 46.
No instruction, Your Lordship.
No instructions dismissed.
Item 47.
I have a very limited grievance for Your Lordship's kind consideration. The writ petition which was filed in the year 2010 came up for hearing. At that point of time, since there was not having instruction with regard to the up-to-date status, the case was disposed of granting me liberty. Your Lordship will kindly find the order dated 7/3/2019.
No instruction, therefore wants to withdraw with liberty to approach the appropriate forum.
I filed a petition for recall saying that the cause of action survives, so it may be heard. I am not having that grievance. My only grievance is the appropriate forum I indicated is this honorable court only. So that much may be clarified. I will file a fresh writ petition because your Lordship kindly see.
All right. It is clarified that in terms of the impugned order dated 7/3/2019, it will be open to the petitioner to file a fresh writ petition in accordance with law.
Deeply grateful, my lord.
All right. The writ appeal is disposed of.
Deeply grateful.
Item 48.
I may permitted to withdraw, my lord.
All right. Constitutional petitioner seeks leave to withdraw the writ appeal, dispose of the problem. Right.
Item 49.
Delay. 685 days. There is a delay of 685 days in filing the present writ appeal, which has not been properly explained. Accordingly, IA number 226 of 20 is dismissed. Consequently, the writ appeal is dismissed.
Yes, but this case shall not be precedent for others, my lord.
Sorry?
This case shall not be precedent for others, my lord. Why, my
All
lord?
right.
While
It was clarified that the impugned order of the learned civil judge would not constitute a precedent. All right.
Item number 50.
Item number 50, this. Sorry, my lord. My lord, item 50, where the appellant, unit of the appellant. But in the meanwhile, a new policy is come into force and we will file an affidavit. Masterly, it will be infructuous, what I observed. So let's say we give this 7 days, we will file an affidavit, then it can be disposed of.
At the request of counsel for the appellant. List on 9th February.
Oblige, man.
Item 51.
My lord, this is the state's appeal. Yesterday, your lordship has entered. Yesterday, your lordship has entertained a batch of writ appeals, my lord, from item number 25 to 40. That's Sarat Parida case, my lord.
Right.
I'm passing over a similar.
When is it listed, sir?
My lord.
Which date has it been listed?
Yesterday, my lord.
Which date is it being listed hereafter?
My lord, the subsequent date, my lord,
What's the point, sir?
My lord, it was listed on
All right.
11/1.
8th May.
Item 52.
Well, this is a matter related to OGLS. The land is settled in the favor of the petitioner well and the OGLS Act, my lord. Subsequent, the Aston settlement officer, they rejected the similar matter. Yeah, lordship has a grant.
All right. Narottam Rath, same.
Item 53.
Not pressed. Not pressed.
Not pressed. Dismisses.
Item 54.
Same.
No.
All right.
My small man.
All right.
My lord, what happened in this case? Unfortunately, the question of law, which has been framed by this honorable court,
Solvent cement eligible to tax under 12.5 unclassified goods.
or entry tax. It is not an entry tax. Unfortunately, the VAT question has not been typed out. Entry tax question has been typed out in this.
Oh.
62 has 63 has not been listed. It is a small amount also.
All right. So what has happened to this 62? Oh, this is the same.
Not listed. If it is listed, it will also not. The monetary limit is only 16,000 some odd.
All right. Not able to understand.
Mr. Rai, STRB 63 is relating to OET.
62 relates to OBIC.
OVAT.
OBACT.
OVAT.
63.
Now which is on board?
This is on board. Obligement.
But
You
the
have
tax
passed
effect
on-
is minimal.
In 63, the tax is very minimum. In 62, the tax quantum is
1 lakh some odd.
1 lakh some odds.
So you have to reframe the questions in 62.
He framed the question 62. Wrongly, it has been.
It is pointed out that in the order dated 18 June 2018, the question framed was erroneous in as much as mention had to be made of the OVAT Act and not the OET Act. Stop. Consequently, the present revision petition is admitted. And the following question is framed for consideration. One, whether the tribunal was right in holding that solvent cement is exigible to tax at 12.5/13.5% as unclassified goods under the OVAT Act. Question mark. That's it. List for final hearing. You've already got a copy.
Ground copy. That is there in the page 14 of the revision petition. This question is there.
You're ready to argue? Argue it now?
I can argue now. My lord.
Are you ready?
Yes.
Very small one point. My lord, the petitioner is a manufacturer, drip irrigation system and sprinkler. I have annexed at Annexure 1, page 17 and 18. These are the systems: drip irrigation and sprinkler. This is treated as an agricultural implements. There is no dispute about that. The dispute is relating to the solvent cement which has been used in this system for using the PVC pipes to the system, whether it will be treated as a cement as unclassified goods or as deep irrigation system. That is a 4% of the OVAT Act.
You're paying for the PVC pipes or you're not?
Everything, PVC pipes, everything.
No, you're paying tax on that.
All taxes.
And then why can't pay tax on the cement?
Not solvent cement is 4%. I have already collected 4% under annexure.
That is different, my lord.
Annexure 34, page running page annexure 5, running page 34. Solvent cement. I have collected 4%.
No. What is the correct rate is the question.
The correct rate is
we are treating it as unspecified.
This is an agricultural implement.
No.
Yes, ma'am.
Solvent cement is not an implement.
Yes,
it is used for PVC pipes.
Is it appearing in part 2, Schedule B?
Schedule B. No. Cement.
Solvent cement.
No.
As a commodity, is it appearing in part 2, Schedule B?
They have treated.
It will go to part 3.
The department has treated as a cement, not as a solvent cement.
Right. You see, although the petitioner has produced invoices to show that what was sold to the petitioner was single quotes solvent cement, admittedly, the said commodity is not separately identified as such in part B of the schedule, part 2 of the schedule to the OVAT Act. Full stop. In that view of the matter, the sales tax authorities were right in classifying it as an single quotes unspecified item, unquote, in part 3, and in subjecting it to tax at 12.5/13.5%. Stop. Paragraph. Consequently, the court is unable to.
It is a whole system has been sold
with the impugned order dated 17 June 2017 of the tribunal and the corresponding orders of the first appellate authority and assessing officer. Paragraph. The question is answered in the negative, that is in favor of the department and against the assessor. The revision petition is dismissed.
Grateful, man.
All right.
Item 55.
My lord, item 55, on behalf of Mr. Subir Palit, I'm appearing.
He is appearing for the opposite party, where petitioner. Let the petitioner go.
Yes, my lordship. Here I am the petitioner, my lordship.
1 minute, sir. 1 minute.
My lord, I pray for some more time, any other date, my lord. As the matter was dismissed for non-prosecution, we need to reconstitute the file, my lord. I love some other date.
Has it not been restored? Is it for non-prosecution?
I think it's not.
When was it dismissed for
It is
non-prosecution?
restored, my lordship. It is restored.
Ah,
It is restored, my lordship. CMPL is restored.
My lord, I humbly pray for some time.
all right. Whom are you appearing for, madam?
Opposite party number 5.
The present writ petition has been restored. Where is that order? It's not there in the scanned order. The present writ petition has been restored pursuant to the order dated 25th March 2019 in CMAPL 433 of 2018, paragraph. Counsel for the opposite party number 5
Yes, my lord.
states that they need some more time to arrange their papers and make submissions. Full stop. We notice that the petitioner appears in person in virtual mode.
No, my lordship, I am not in virtual mode, my lordship. I am the advocate for of the petitioners, my lordship.
All right, you are appearing in virtual mode, sir. Maybe
Yes, my lordship.
Counsel for the petitioners is appearing in virtual mode. All right. List on.
Obliged.
11th May.
Item 56. I need some time due to daughter's marriage. I could not read the brief. I have only anything I can say out of the memory. I have not gone through the record.
Whom are you appealing for?
My lord,
the background of the case is like this.
My lord.
Lordship, kindly see.
WPC
WPC
7 here, my lord. I require some
7844
time.
of 2014. The order was passed.
My lord, I can place my out of my memory, my lord. My lord, let him sit. I will place. If he is interested to argue the case, I am not ready. I have not gone through the record. But out of memory, I will place, my lord. My lord, this is a case, my lord. The PIL was filed in 2014. Without making us party, my lord, the order was passed to evict them. My lord, the Tahsildar, without adopting the process of law, sent the police and manpower to evict. This is a place consisting of 10 acres. A village has been grown. Electricity, school, colleges, and all landless poor people are residing there in the near to Baluga, my lord. This migration was grown in 80s, my lord. 2 generations are residing. My lord, without any adopting the process, they wanted to eviction. We know when the contempt action was filed. Then we have filed a review. Then we have filed a writ. No process law has been adopted, my lord. Simply, my lord, they are implementing the order passed in the PIL, my lord. The PIL filed by the neighboring villages out of their jealousy, my lord. And it is a totally 10 acres of land. Vast population has been grown. The Lord will find in my requisition school, colleges, temples, everything, my lord. And this is I have attached all the documents, my lord. Electricity and even also the houses has been provided under the government scheme. Electricity has been provided. And they now want to demolish without adopting the process. We are landless people, my lord. And the whole village will be smashed. Only on the order of a PIL, we are not partying before them. I want to place the matter because the village has been grown. But as in Annex 1, I have annexed the identity card, voter ID, my lord, then ration card, then the paragraph 6, the electricity has been provided under the government scheme, my lord. And several persons are BPL, my lord. Poor people, my lord. Then, my lord, I have also stated school, my lord. The petition humbly submitted government land, there are Ayurvedic hospital, post office, primary school, high school, Soran Gram Panchayat, Sesu substation, two transformers has been installed, my lord. the population has been grown. It is the government to take a policy decision. Whether they matter
gone to the
no.
against the order.
I'm saying no.
Disclose.
No. I will disclose everything. I will disclose everything I have started. No, I will started. No, I'm filing my lord, paragraph 18. The petitioner filed SLP bearing diary number such and such. He is saying that I am not suppressed number. And on 14, the same was withdrawn at the stage of admission.
That is not correct. Not withdrawn.
First you have said that suppressed. Now he's saying another thing. Don't interrupt me. You keep present. I will not suppress anything. Well, thereafter I filed a review petition. Since that bench was not available, this petition was filed. This is a crucial matter. The thousands of people will be thrown away by that. They are residing from my teeth. So you have to give me some time. After the marriage of my daughter, I will place my daughter, everything, my daughter. I will not press anything. And they are neighboring villages, my lord.
No.
They want to, don't interrupt. You are not going to maintain the decorum of the court. No, interruption.
1 minute. There are two judges sitting here. If you want to have a conversation, please go out and have the conversation. Advice about maintaining decorum without maintaining decorum yourself.
My lord, I'll do that, my lord. All these situations are there. Number of people are there. I only want that after my daughter's marriage, I'll place the case.
You place it now. Whatever time you want to read every paragraph. Slowly you read it.
Place the documents.
All right, read it. Read it. We'll read it with you.
Well, then okay, my lord. If you will manage. Well, this is a population has grown nearer to Chilika Lake by some landless persons, my lord. In 80s, my lord. More than 10,000 people are residing in different government lands, my lord. Then, my lord, the petitioners have given electricity from 1999. Poor BPL category got electricity on Biju Jyoti scheme. Names of, no, I have disclosed the names. They got the electricity by the government scheme. Electricity bill also attached. My lord, the 9 petitioners are belong to BPL category, my lord. They deserve to get benefit under the Appeal Act because they are landless persons, my lord. 4 series BPL card I have enclosed. Then, my lord, proceeding was initiated from 93 by the Revenue Authority. They have collected the penalty, my lord. And some cases, some persons have been on occupation more than 30 years, some person's land has been settled by the Tahsildar, by local Tahsildar. My lord, 9 persons from APL category, I have given the names, and Antodaya Yojana, they are getting the benefit for their poor people, my lord. My lord, in paragraph 10, out of them, one Prafulla Kumar Sahu, his name, the land has been settled, my lord. By the Tahsildar, I have given the reference. My lord, even there are some religious festivals are done there. Lord Vishwakarma, Lord Raghunath, Lord Mahavir, installed by the villagers residing in the government land, my lord. They are worshipping the God and goddesses. My lord, I have given the photographs, my lord. This is a large population. Then, my lord, that Ayurvedic college, post office, primary school, high school, Soran Gram Panchayat, Sesu office, 2 transformers was installed, my lord, in the government land, my lord, for the benefit of these people, my lord. Then I have stated that as a matter of policy decision, government can grant the settlement of the land because these are landless people and poor people, my lord. But the government has not taken any decision, my lord. Only on the direction of on PIL, my lord, they try to evict, my lord. Then, my lord, that filing of the PIL in 2014, we have not made party in that PIL, my lord. Some people came, they filed, and without notice, the order was passed by the PIL, my lord. I filed the review, I gone in SLP, then review, then read, my lord. Because they want to straight away execute the order of the passed by the PIL, my lord, because they filed contempt. I quoted that the order of the decision of court, my lord. Then regarding filing of the SLP review, then this retribution, my lord. My lord, then we have also filed before the application that before the Tahsildar that since you are landless persons, you first consider our case for settlement, my lord. After rejection of that, you may go for an encroachment. That application is still pending from 2015 before the Tahsildar, my lord. As per the requirement of the law, they have to consider, conduct an inquiry, and thereafter go for the eviction, my lord. That it series the application for settlement, my lord. BPL card holder, green card holder, my lord, they are entitled to get benefit under the statute for settlement, my lord. Section 7(2) and 8(a) of the PLA Act, my lord. That has not been considered, my lord. Because there is no individual notice, only on the order passed in the PIL, who are not party, they want to evict us, my lord. So, my lord, since our people, this, as per Article 21, my lord, they should not be driven out of the shelter home, my lord, without giving any alternative mode, without adopting the process of law, my lord. I have only stated that in my prayer that you consider our application for settlement. If on an inquiry that the prayer part I have stated that the process of law may be adopted, my application for settlement may be considered, and thereafter any eviction if government want to take, may take without by adopting the process and procedure of law, my lord. That is the only prayer before my lord. And these are poor people, they are residing from 80, my lord. And these people are extremely poor, my lord. And they have not been noticed, neither by the Tahsildar nor by this court, my lord. Well, this will amount to a vast eviction in the state of Orissa, my lord, and the lordship to protect under Article 21 of the Constitution of India.
Who were you appearing for, sir?
My lord, we are interveners, those who are we are read petitioners.
He was the petitioner in the PIL where eviction order was passed.
That eviction order was passed, your lordship will
So
find.
just tell us about your.
My lord, 30, why that occasion came for filing the PIL, that your lordship kindly see the order we have annexed, that miscase number 1357 of 2016.
1357.
1357.
All right.
Lordship kindly see the order. We have sought for intervention in this case, that is Annexure B/4, page 17. Your lordship will get it in page 20.
Yes.
My lord, the petitioners who are the villagers of village Bhagavatipur, not other village, the same village. Under Sorona Gram Panchayat in the district of Khurda have approached this court seeking its intervention to get the land measuring 3.430 decimals in Hal Khata number so and so of the said village clear from 33 encroachers. The petition reveals that this land is Gojjara, and meanwhile 33 encroachment cases have been registered against the unauthorized trespasser, who have also raised illegal construction of permanent nature thereon. According to the petitioner in the said encroachment cases, though notice had been issued from the year 2010, the encroachers have not yet been removed. Being agreed by the inaction on the part of the said authorities, the petitioner have thus approached this court. The opposite parties in their counter, while admitting that the land involved has been encroached upon by 33 persons against whom an equal number of
encroachment cases have been registered and they have in the meanwhile been adjudged as unauthorized occupants of the government land, have stated that actual eviction order or work would be carried out if necessary by deploying police force after the disposal of the instant proceeding pending before this court. That the RI Jaripada meanwhile by office letter dated 4/6/2014 was directed by Tahsildar Chilika to stop further construction on the vacant plot and to take necessary steps to protect the same from the encroachers has been stated as well. After hearing the Learned Counsel for the parties and noticing the pleaded stands as above, we are of the view that the opposite parties ought to take immediate effective steps to get the aforementioned plot cleared of the encroachers and the unauthorized structure thereon at the earliest. However, in accordance with law, order.
One minute. So who appeared for these 33 encroachers?
He appears.
Mr. Rath.
No. Just see the appearance. 30th October order, right? Go to the beginning. What you're reading, sir? Same page.
Same page.
Just the previous page.
Previous.
The order starts first paragraph. You just read that.
My lord, page 20, my lord.
Sir, the order begins the first line of the order. Please read.
I had Mr. Mahanti, Learned Counsel for the petitioner, and Mr. Patnaik, Learned Counsel for the opposite parties.
What does that mean?
No, I think they were not implemented as parties. In
33 encroachers must have been implemented.
No, encroachers were not.
My lord, here what has happened? Already encroachment cases, final order passed.
Where the question of passing this order without implementing those 33 encroachers?
That is there.
That's very fundamental flaw, sir.
Not included as
There's fundamental flaw in this order.
My lord, your lordship will find from the writ petition, my lord, already the final orders had been passed, wherein they had not challenged. They had not challenged.
There is the question of getting orders in this kind of manner without implementing these 33 people.
And they had carried to the apex court which were dismissed.
Where's the question of they were not even parties? How can they carry it?
Your lordship kindly see simple dismissal is there.
No, but where are they made parties, sir?
My lord, what has happened in that PIL, basing on the counter affidavit?
Even today, we don't entertain PILs because people keep naming many encroachers. We never entertain. We say unless you name the encroachers and unless you implement those encroachers, we will not pass orders.
But my lord, one thing, my lord, it strike to my mind subject to lordship's appreciation. My lord, final encroachment order was passed in 2010. That was not challenged by them. It was accepted.
Who's them? The court doesn't even know who's this them you're referring to. My lord, who are you referring to? This bench is sitting, right? This bench has passed this order. Does this bench know who these 33 people were?
That was given in the writ petition?
No.
Yes.
Where is it?
In that writ petition that was given.
Where is it?
In the writ petition 7824.
No, where is it given? You tell us. Because they're not implemented as parties.
They are not implemented.
Suppose you gave some Ramesh, Suresh and all. There is no such Ramesh and Suresh. How will you know? Suppose you named 33 people in a slip of paper, like a judge, like I'm asking you, that bench asked you, you wrote out in a slip of paper 33 names and gave it to the bench.
No, that was given the public document. That was public document.
No, not made parties here. Not made parties here.
That writ petition, your lordship must be there. I think
they were not made parties.
They are not made parties, right?
Admittedly.
That is so fundamental, sir.
But
that is a fundamental flaw.
But your lordship will find that in that writ petition, everything has been brought to the notice of the
No. Not mentioned. No lawyer heard. No lawyer appearing for those 33 people.
I think Mr. Patnaik may be for the government.
Yes.
Maybe
My lord, may kindly see the third paragraph of that order. The opposite parties in their counter while admitting that the land involved has been encroached upon by the 33% against whom an equal number of, and this is the counter affidavit of the state government, where from the court came to a conclusion that the land is under unauthorized encroachment of 33%. Accordingly, direction was issued.
What happened to this review petition?
Review is pending.
Pending. We'll call for the review.
My lord, that is first ground in my review application, my lord.
1 minute, sir.
Already connected, my lord.
Both are listed.
Show us the review petition 1 minute.
Only for a moment, your lordship may kindly come to that annexure 12 of the writ petition.
Best way is to allow this review petition, implement them as parties, and hear the writ petition.
But your lordship may do that. But it has reached the finality after the apex court dismissed the writ petition.
That
No,
was
that's
dismissed in
dismissal.
limine.
Puni Ahmed, it's not a final order. It's not an approval of
There
the
was
order.
no adjudication in Supreme
No,
Court. It
that
was
is not
dismissed in
Two
limine.
line, one word dismissed.
Yes.
And this is very well settled. The review is maintainable.
The
against
lordship is entertaining review application even after dismissal in the
SLP.
if it is dismissed in limine.
One line, yes.
And Mr. Roth is there to appear for those parties.
Yes, yes.
And your
Yes,
lordship may-
yes,
I will
yes.
appear, my lord.
All right. Take up the review
My
petition
lord, in
first.
that event, the second writ petition
May not be necessary.
is not necessary. He can make such objections or claim in his counter.
Because we would have
affidavit also.
recalled the entire order.
Yes, yes.
Then you file the
And
counter affidavit in the
subsequent writ
petition.
petition and there is a contempt petition
Correct,
that may be
correct.
dropped.
Correct. No. 16 January 2017. Oh, must have been restored.
Yes, that was restored. Sir.
Restored because of CMAPL.
Review my lord 227 of 14.
Right. You say
Okay.
in this review petition seeks the recall of an order dated 30th October 2014 passed by the division bench of this court. In writ petition civil 7824 of 2014. Paragraph, a perusal of the said order reveals that the main prayer by the original writ petitioners was for implementation of the orders passed purportedly under the Orissa Public Land Encroachment Act against 33 persons named as termed as single quotes encroachers, unquote. Full stop. The grievance was that the authorities were not taking steps to remove such single quotes encroachers, unquote, on government land. Paragraph. A perusal of the order reveals further that none of those 33 single quotes encroachers were made parties to the writ petition. Full stop. There were only 7 opposite parties in the writ petition. They were represented by Mr. Patnaik, Learned Counsel. Full stop. The order further reveals that only 2 counsel were heard. One, Mr. Mohanty, Learned Counsel for the petitioner, and the other, Mr. Patnaik, counsel for the state. Opposite parties, 1 to 7 bracket. In other words, neither were the 33 single quotes encroachers made parties, nor was there any occasion for anyone to appear on their behalf when the writ petition was disposed of by the above order dated 30th October 2014. Paragraph. The said order was adverse to the said 33 encroachers, so-called encroachers, as the operative portion of the order was a direction to the collector, Khurda, to open quotation, ensure in coordination with the other authorities as may be considered necessary, unquote, eviction of the single quotes 33 encroachers with their constructions in the land mentioned here and above, unquote. Full stop. Paragraph. When the petitioners came to learn, when the present review petitioners, that is the said, you are only 20 of you, not 33.
No, my lord.
When the
But
present,
I have to verify whether the cases against this person or any other person, my lord.
anyway, when the
Because-
present 20 persons, 20 review petitioners came to know of the aforementioned order, they first filed SLP civil CC number 21067/2014 in the Supreme Court of India. Full stop. The said SLP was listed for hearing on 17th December 2014 when the following order was passed, open quotation, taken on board, dot, next line, dismissed, dot, unquote. The SLP was therefore dismissed in limine without any reasons. Full stop. It is now well settled by the Supreme Court of India in a series of decisions, including Kunia will give you the citation, that an in limine dismissal of an SLP at the very first hearing does not mean a confirmation of the order of the High Court against which such SLP has been filed. Paragraph. Thereafter, the present review petition was filed. On 24th December 2014, praying for recall of the judgment dated 30th October 2014. Principally on the ground that the review petitioners were not made parties to the writ petition in which the above order adverse to them was passed. Full stop. The said review petition, this review petition was once dismissed on 16 January 2017 for non-prosecution, but was restored by an order dated 20th March 2018 in CMAPL 51 of 2017. Paragraph. In the meanwhile, these very petitioners also filed writ petition civil 23099 of 2015 on 21st December 2015, in which an interim order was passed by the court on 8th January 2016, directing status quo to be maintained in respect of the land in question, that is plot number 2115, measuring AC 3.430 decimal at Moza, Bhagavatipur, Tehsil, Chilika. Full stop. That interim order has continued. Paragraph. This court has heard the submissions of Mr. Shrikar Kumar Ratha, learned counsel appearing for the review petitioners, and Mr. Pradeep Kumar Manti, learned senior counsel appearing for the intervener, the original writ petitioners. In writ petition civil 7824 of 2014. Paragraph. Although Mr. Monti contended that orders had been passed against each of the single courts, encroachers, unquote, and the only issue was about non-implementation of such removal orders, it was not considered necessary to implead specifically each of the said single courts encroachers as parties to the writ petition. Paragraph. Once it is plain that the writ petition is seeking orders against such single courts encroachers, unquote, it was absolutely imperative for the petitioners to have impleaded them as parties to the writ petition. Stop. No order adverse to such persons could have been passed without giving them an opportunity of being heard. Stop. This is irrespective of the fact that they may have been heard in the proceedings initiated under the OPLE Act. Full stop. Paragraph. On that short ground, this court recalls and reviews the order dated 30th October 2014, passed in writ petition civil 7824 of 2014, and restores writ petition civil 7824 of 2014 to file. Full stop. Then paragraph, that separate order, writ petition civil 7824 of 2014, this writ petition has been restored pursuant to the order passed today in review petition 227 of 2014. Full stop. Paragraph. Each of the
review petitioners.
20 review petitioners in review petition 227 of 2014 will stand impleaded in the present writ application.
21.
Review petitioners are 20, sir.
21.
21 and 22.
Will stand impleaded in the present writ petition as opposite parties 8 to 28. as 8 to 27. Paragraph. Mr. Shrikar Ratha accepts notice on behalf of the newly implemented opposite parties 8 to 27 and states that the reply to the writ petition will be filed within 4 weeks. Full stop. Since more than 8 years have elapsed since the filing of the original writ petition, the court directs the state authorities, that is opposite parties 1 to 7, to file a supplementary affidavit.
Oh, supplementary.
Supplementary affidavit,
Because
bringing
the
on
original
record any
affidavit
further
is already on
developments.
record.
Yeah, any further developments and specific particulars pertaining to the present newly added opposite parties. Because they say some of them you have already settled the land in their.
I will ask them to conduct an inquiry and submit a report. Who are the actually, what is the nature of possession? And
all right, at this stage, Mr. D.K. Mohanty, learned additional government advocate, says that the authorities will be asked to conduct a proper inquiry into the present status of each of the newly added opposite parties and submit a report. Full stop. The said report be placed along with an affidavit within a period of 12 weeks from today. Full stop.
My lord, 1 second, my lord. My lord, copy of writ petition director maybe showed me. In my case also.
You have that writ petition, sir. You have that writ petition. That's how the
rebook would have been filed.
Yeah. You have that writ petition with you. You must have filed SLP also. You must have filed with that writ petition.
My lord, another mean my writ application counter is necessary.
No, that writ application.
That writ petition is not necessary now. Just listen to the order. There is no adverse order against you now.
Not necessary.
No need for that.
Not necessary.
Now he has to now be, his anxiety is now going to start.
This must be anxiety of the state.
More spirited land is occupied by public spirited.
No, state land is occupied.
Status quo order can be continued. Status quo is there, it can be.
Yeah, you say it is made clear. You say it will further be open on to the writ petitioners to file a rejoinder to the affidavit of both the newly added opposite parties as well as this additional affidavit of the state before the next date. Full stop. You say list on. I think you spent the summer vacation peacefully.
After summer vacation.
Yes. List on 17th July 2023. Full stop. It is made clear that the newly added opposite parties will not alter the status quo.
Yes.
In any manner. All right, we don't want you to now get ideas.
Director for 20% impletion, 33 allegation is gone.
You have come, only 20 has come forward, sir.
You cannot
come forward.
Whoever has come forward will get the
so
benefit.
far as 23099 is concerned.
No, I'll just pass that on. Then separate 23099 of 2015. This writ petition had been filed during the pendency of review petition number 227 of 2014, filed by these very writ petitioners. Full stop. Today, the said review petition has been allowed. And the order of which review was sought has been recalled with this order of which the review sought, that is the order dated 30th October 2014 in writ petition civil 7824 of 2014 has been recalled with this court. Full stop. That writ petition has been restored to file, impleading these writ petitioners as opposite parties. Full stop. In view of the above developments, the present writ petition did not be entertained with this court.
Well, there is an interim order, status quo is there.
It stands disposed of. The status quo order is vacated since there is already a corresponding order passed today by this court in writ petition civil number 7824 of 2000.
Then CONTC 1406
that may be dropped.
2014.
Contempt.
All right.
My lord, CONTC 1406.
CONTC in view of the order passed today in review petition 227 of 2014 and writ petition civil 7824 of 2014. This contempt petition has become infractuous and is disposed of as such.
My lord, maybe excuse, another case can be disposed of. 138 of the main weekly list that is covered by your lordship's judgment. That is
Narottam Ratha.
Narottam Ratha.
Yes, that day I was also arguing on 2nd January your lordship delivered that.
That's what.
My lord has given an advance gift to Mr. Ratha for his daughter's marriage.
Correct. So you should not have asked for adjournment. You did not know. You did
I
not
am
know.
returning in late night by every day. And today also money I could not open my brief.
Still you won
That
the
is my
case.
obligation.
See,
for
you
court.
succeeded, but I hope that the younger lawyers in the court shouldn't take the lesson that without opening the brief, you can win the matter.
Very physically very difficult, my lord. To read the volume file in the morning, very difficult. At my age, my lord. I am now 64. So I cannot take.
Sir, I'm only 2 years younger than you.
I to be more energetic. Mr. No, I am more energetic, my lord. My energy level is low.
My lord, 138, your lordship dispose.
Yes. Same order. All right.
Item 57.
Lordship, I am for the petitioners.
Yes.
57.
Lordship's order dated 22nd, 11/22.
Yes.
Affidavit from Panchayat Raj Secretary.
File the affidavit. Is that official present or not? Yes, to remain present. We'll pass it over. Ask him to remain present.
Yes,
in virtual
yes,
mode also,
yes.
he can come.
Yes.
Ask him to be ready with the entire file. Let him be in virtual mode at 2 o'clock. All right. We'll call it at 2 o'clock, sir. Mr. Pani.
Yes, Lordship.
At 2 o'clock. All right. Please ask him to remain present in virtual mode. Yes.
Item 58.
See, Mr. Mohanty, that 25,000 figure is such a magical figure. If you had put that in this order, he would definitely be present today.
My lord, there was no personal appearance in the last order.
No, there is.
The commission comes Secretary Panchayat to file an affidavit specifically dealing with the above and appraising the current status of the said proposal. The affidavit be filed within 4 weeks with an advance copy. There is no personal appearance.
1 minute, just which is that item?
Lordship may read the order dated 24th September 2022.
No, 22nd November, sir. You're showing the 22nd November order. See, this is the other problem. If you don't have a copy of the order, then you don't have to comply with
the copy. I got it. Sorry, I'm very sorry.
That clearly says failing which he shall remain present in virtual mode.
The secretary to comment.
2 o'clock.
Yes.
2 o'clock.
Right.
Yeah.
Item 58. 58, my lord.
Let him not simply come. Let him. He's got time, 1.5 hours.
Yes.
Let him go through the file and come with a proper response. Yes.
Yes.
My lord, I'm the petitioner in this case, my lord.
Yes.
And sir, case, my lord, railway link from Raurkela to Talcher, Raurkela, my lord. That's the lifeline of the Odisha. That will be the lifeline of Odisha, my lord. Since 1952, the people of Odisha are hesitating for this one. And in 2003, it was sanctioned by the railway department, considering the grievances of the people. Since 2003.
Now you have a railway minister who's from here, sir.
My lord, railway minister is
it's the best time. And Mr. Padi is very,
Mr. Padi
very active now.
Railway minister.
You please go to Mr. Padi. He'll get it all done.
Padi's grievances, my lord. In his counter, he has stated that in 2 districts there is a nil acquisition, land acquisition. In Devgad and Sundargarh, there is nil acquisition. My lord, since 19 years back, it has been decided, and now the status is a nil acquisition, my lord. How this project will be completed?
I'm just clarifying. My learned senior may not be aware of this. Railway has paid the entire amount to state. What happened? So many LA case was being filed before this court, and interim order was passed. After 7-8 years, now we have listed the matter. After this matter was railway matter was coming to us, it was vacated, my lord. Now, under the process of doubling, only thing is the state government should extend their cooperation to vacate them physically. They are giving only symbolical position somewhere. So I ran my request, my friends. We will both of us will take all set up in this regard. Let's make keep it some other day. In the meanwhile, this whatever amount is in paid, how much accord is in paid, we'll give the detailed data. Then it is a Bimlagar line, Talcher Bimlagar line. Yes, we have given the all details in page 16, 16, 17. We have paid the amount. Question of payment is not an issue here. It is that how rehabilitated and they have evicted and this free land is given, railway can start the war. This is the only issue.
No, my submission to extend.
No, just like the lesson from the previous matter, sir. If some people are going to be evicted, you better make them parties.
No, my lord, I think there will be no eviction. My information is there are 3 types of land that have to be acquired. My lord, just 1 minute, my lord. 3 types of land. One is private land, one is government land, and the other is forest land, my lord. 3 types of land. Forest land and government land, that does not need any acquisition, my lord. That can be handed over.
Again, there will be people sitting there, sir.
No, my lord. Forest land, there is no settlement. I think that
don't say think. If you undertake a survey, you'll find out who's where.
300 crores rupees has already been deposited by railway with the government of Odisha, my lord. But these land acquisition officers.
So end of the day, you'll be faced with a human problem. All right. If you don't implement them as parties, they're bound to come. One day, one bulldozer will stand in front of their house.
No. All the lands. And my information is all the railway link is running with the forest. There will be no eviction, I think. If at all, very lucid manner, the state government has now giving crores of rupees towards land acquisition in government, Jagannath Temple and other areas, my lord. That can be settled. Within the government desires, that can be settled within no time, my lord.
I'm just telling you, it's up to you. If there are persons there who will face eviction as a result of orders that you want to be passed in this petition, it is in your interest that they are heard right now. Otherwise, you'll never be able to get the land. The same problem. And if there are thousands of people, even more difficult.
Let my friend, the state council,
actually, sir, you need to have only out of 309 crores.
See, he made a very nice, submission covered in a lot of the best kinds of words.
19 years has already been passed.
So what he said was state government is not cooperating in getting the land, possession of the land. Only symbolic possession they're able to give. What does that mean?
That doesn't mean anything, my lord.
Of course it means, I mean, as two judges, it means a lot to us. Lawyers in the room, it means a lot to them also. Symbolic possession means on paper possession is given. Actually, on the ground, you're not able to give possession.
Such symbolic possession has been given. Let my friend file an affidavit regarding the present status, my lord.
That's what. Let them find out
state may
who's
be
there.
directed to file an affidavit in this regard. It will surprise the problem.
I mean, not the collector Sundargad and collector Devgad, my lord. Devgad is a district, there is no railway link, my lord. That will be great beneficial to that district. Okay. And that collector is sitting right. Lordship may.
What's the position on this?
Let both the collector file affidavit for lordship. Both the collector file affidavit. Why there is asking the lordship may ask them why there is nil acquisition till date. 19 years past.
And look, there is already a counter affidavit filed on 14th September 2021.
Let's see that.
My lord, 400 kilometers will be shortened. 4 hours will be less than the present traveling time, my lord. That is a great beneficiary for the state, my lord.
Paragraph 9 of the affidavit. This affidavit is shown by Ashish Kumar Bhoi, Land Acquisition Zone Officer, Talcher Vimlagarh, New Busy Rail Line. Paragraph 9. That in reply to the averments made in paragraph 6 of the report, it is humbly submitted that it is not a fact that the government of Odisha has grossly neglected in providing the required land to East Coast Railways and shown apathy to the long cherished demand of Odisha people, their duty for construction of the Talcher Swanspo project. The requisitioning authority have filed requisition as per 2013 Act, where justification for adoption of emergency procedure have not been included. It is crystal clear that in section 17(1) of the Land Acquisition 1894, in case of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, may, on the expiration of 15 days from the publication of notice mentioned in section 9, subsection 1, take possession of any land needed for public purpose. Such land shall thereupon vest absolutely in the government. But the proposal for land acquisition in respect of Devgad Sundargad have been filed by Railway under 2013 Act, where special power in case of urgency have not included, and preparation of social impact assessment study as per section 4 of the Act have been implemented, and 6 months time have been granted to completion of SIA study by independent agency as per section 7 of the 2013 Act, 2 months have been granted to an independent multidiscipline expert group to submit recommendation on the SIA study. On the other hand, after publication of preliminary notification on section so and so, opportunity for hearing of there are a lot of procedures that we have.
Procedures that should be completed once. Once it will look up. 19 years has already taken. How much years will take complete?
Regarding government land, permissible possession have been granted by the district administration in Devgarh and Sundargarh district. The land action zone officer has been functioning in Sundargarh district. The government have been posted one ORS officer to act as LA collector who monitoring the land action work in Devgarh and Sundargarh district. A camp office at Bonai has also been functioning for smooth management of the public work to avoid delay in land acquisition.
One thing I pray, Lord.
Then, para 12, sub-para, an amount of rupees 40 crores odd has been received towards acquisition of land in respect of 19 villages covering an area 188.240 of Devgarh district, 29 villages covering an area so and so in Sundargarh district. The declaration under section 19(1) so and so in respect of 14 villages have made out and 19 villages of Devgarh district. So this was the status as on 14th September 2021. If your lordship will say, then I can file an additional affidavit stating the current status.
What are the further steps taken?
Yes, ma'am.
Right. In an affidavit filed on 14th September 2022 by Shri Ashish Kumar Bhoi, Land Acquisition Zone Officer, Talcher Bimlabgarh New Broad Gauge Rail Link, Sundargarh District. It has been stated in para 8 that for the purposes of the above railway line between Talcher and Bimlabgarh, covering 3 districts, that is Angul, Devgarh and Sundargarh, AC 2153.531 decimal private land is required, of which AC 513.481 is in Devgarh district and AC 479.960 is in Sundargarh district. Full stop. This extent of land includes private land to the extent of 435.760 acres, government land to an extent of 280.550 acres, forest land of 283.131 acres. Full stop. The private land in Devgarh district covers 19 villages, comprising 188.120 acres, and the private land in Sundargarh district is to an extent of 247.640 acres, covering 29 villages. Paragraph. The affidavit sets out the steps taken under the land acquisition, that the whole RFC, TLAR and R Act 2013 for acquisition of the private land for being handed over to the railways for the purposes of construction of the line. Full stop. It is seen from the said affidavit that while in both Devgarh and Sundargarh, some portion of the government and forest land has been able to be alienated or diverted. There is absolutely no progress made as far as actual acquisition of private land is concerned. Full stop. The affidavit acknowledges the receipt of amount towards the land acquisition from the railways, but states that the process of completing the steps under the 2013 Act is still ongoing. Full stop. Paragraph. It is therefore not clear what the timeline for completion of the land acquisition process in both Devgarh and Sundargarh is as far as the private land is concerned. Mr. D.K. Mantil, an additional government advocate, states that a supplementary affidavit will be filed to update the status of land acquisition in both Devgarh and Sundargarh for the above project. Full stop. Paragraph. Even as regards government land, forest land, and department land, it is seen from the affidavit that not the entire land required for the purpose of the project has been handed over to the railways. To stop, the timeline for doing this will also be indicated in the affidavit. Paragraph. Mr. Padi, learned Deputy Solicitor General of India, informs the court that in many instances, only single quotes symbolic possession unquote of the land has been given to the railways and not actual possession. Full stop. The affidavit to be filed by the state will deal with this aspect as well. Full stop. Paragraph. It is also made clear that the status of single quotes encroachments unquote on government land, forest land, and department land must also be indicated in the affidavit. And the steps taken to must also be indicated. Full stop. This will be factored in while setting out the timelines for actual handing over of physical possession of the land required for the project to the railways. Stop. The supplementary affidavit will be filed on or before July 2023. List on 1st August.
May I pray, my Lord? Lord, so may I direct the state government to invoke this special provision of Land Acquisition Act?
Apparently, there is a. If you read that affidavit carefully,
in their affidavit, they have said that it has not been requisitioned by the railway, my Lord. Let that process be adopted here. Lordship may think of 19 years has already been taken.
I know, sir.
My Lord, can we reflect one thing, my Lord? Sorry, my Lord, Lordship, can you reflect one thing? In our counter, we have given this how much already acquired, how much is required to be acquired, balance is there. Government land is there no bar to give us. So in that process, state government can, without any prejudice, they can proceed to give us the. I've mentioned that. I've said not entire government land has been handed over. So let's give a timeline within which they will hand it. That's why I've asked them to tell us about encroachments. Yes. If there's encroaches on forest land, government land,
their affidavit is the forest land has already been handed over. Already been handed over.
One portion, sir, not the entire portion. And read that affidavit carefully. The entire land has not been handed over.
My Lord, in a government land also can be handed over.
I don't know about the other issue of if it is forest land, environment clearance. I don't know if you've got it for that.
Forest land is already been acquired.
Yes, already been handed over, acquired and handed over.
Private land is
balance. No, do you have environment clearance for that?
My Lord?
That
you have
clearance is required under the forest.
And that has already given. Clearance has already been given. Already handed over to railway department.
That counter copy may be.
Yes, that comes.
Because otherwise I cannot.
The railway has filed a very clear counter, my Lord. Taking all the facts.
And in past case, Mr. Gyanaluk Mahathi is appearing. Along with second case, Mr. Bhukta is appearing. All right.
Lord, so may fix a date.
I have
already
fixed. First August. Right.
Item 59.
May I please, the PL matter, my Lord. This is the second joining of the petitioner to this honorable court, my Lord. As because on first application, WPC number WPC 182220/2010, my Lord. And that, my lord, the order passed on 21/1/2019, my lord, at page 20 of my petition, my lord. That case, my lord.
Again, only filing representations.
My lord.
That was only to make a representation.
My lord, this honorable director to make a representation, my lord. And the, my lord, the specifically direction that, my lord, the authorities shall do well to consider dispose the same in accordance with the law by passing a regime order as expected as possible, preferably within a period of 8 weeks, keeping in view of the implementation of a prohibition of cow slaughter and Animal Prevention Act by other state, my lord. Although I had given, my lord, by the time, so far Andhra Pradesh and the UP and Punjab, other states are, but the act itself, my lord, in the year 60, my lord, 1960, my lord, 60 Act, my lord, 22 Animal Act, my lord. And so far the Odisha Prevention of Orissa Prevention of Cow Slaughter Act 1960, my lord. Rule came, my lord, 1966, my lord. But in the meantime, my lord, day by day, the cow challenge and cow slaughtering increasing in our state, my lord, increasing in our state, my lord. For that, in my regender, I had given 29 cases, my lord, after the order passed by the Honorable Court, my lord, 22, my lord, that are rising day by day, my lord. That act should be amended, my lord, like other states, my lord. That part they have nothing to do, my lord, they have to do something so that the cow challan and cow slaughtering day by day increasing, that can be stopped, my lord. The government, my lord, has to take appropriate steps like other states, my lord, the state of Punjab and Haryana, my lord. That is tax force and the IG, one of the IG, my lord, they deployed in that case, my lord. Here, man, in Odisha, my lord, there is no specific tax force, my lord, in order to prevent that the cow challenge and cow slaughter, my lord. Other states, my lord, they have amended, my lord, the UP and other states, my lord. That is the order of the taking to consider my earlier application, my lord, this one director. Also, I have provided in that case some states amendment act. Amendment of the acts and also rules, my lord. That has not been taken into consideration while disposing my representation.
No, what you want is a special task force for implementation.
But task force, if the, my lord, the IG level officer, my lord, can be, my lord, the deployed, my lord, the forces, my lord, that can be stopped, my lord.
No. How many registered cases, sir? In
29 cases, my lord.
In the whole year or over several years?
My lord, after the order passed by this Honorable Court, my lord, 19 and 2021.
No, so in the whole year, let's say in 2021 and 22, how many cases?
19 and 22, my lord.
Some 3 cases or 4 cases.
My lord, 29 cases I have given, my lord, in my regender.
No, that includes 2019 onwards.
My lord.
This is 2019, 20, 21.
21, my lord. 22, one case, 22, my lord.
So what, which means works out to not even 7 cases a year.
I had given that, my lord. Apart from these cases, my lord, there are other cases, my lord, those are available with me. I have given, my lord, that case.
How many cases per year? Let's find out. They'll tell us how many cases are
as per our affidavit, my lords, with regard to cow challan and illicit cow challan and transportation, my lords may take my affidavit annexure A by 4. Which is at page 7 of.
So the whole of 2021, 371 challans.
371 challans.
How is it, sir? This is hardly a number. 371 means one a day.
One.
Not what you're trying to make out some alarming figure and all you're giving. Nothing like that.
An SOP
this is hardly anything, sir.
They have to amend the, my lord, rule and the act, my lord.
That is a different thing. So we can't.
That is our.
The court can't issue mandamus for those things. That is settled law.
Earlier, this court honorable directed the state council.
As in fact, my lords, we filed another affidavit on 12th of December. And there, my lords, we have given the reasoned order disposing of the representation with regard to the previous writ petition. My lords may find that at page 7, annexure A by 6. On this
December?
Yes, my lords. 12th December 2022, counter affidavit on behalf of opposite parties number 5 and 6.
Where is that? 103.
The page 10, my lord. 6th paragraph, they have mentioned, my lord, the petitioner suggested that the government should take necessary steps for amendment, reformulation of rules, guidelines like state of Andhra Pradesh, Assam, Bihar, Goa, Chhattisgarh, Delhi, Gujarat, Haryana, Jammu and Kashmir, other states, for the benefit of cow progeny and farmers in the state of Orissa, that the matter will be examined. They have, my lord, they admitted them their counter, that matter will be examined, my lord. When they will examine, my lord?
Well, let's wait. He filed it on 13th of December.
No, we have the affidavit here. Tell us which one.
Please wait. Well, it's page 7, my lords. My lords, on this specific issue that is dealt at page number 10. The last line, my lords. Whereas the petitioner has suggested that the government should take necessary steps for amendment or reformulation of rules, guidelines like state of Andhra Pradesh, so and so, that matter will be examined. That is, my lords, the...
That's okay. But what does that mean?
Whereas we have not taken a decision on whether to amend or to bring in new regulations.
While disposing the earlier rate application, this one was specifically directed to dispose of the repression, taking into consideration the amendment of other states. That they are not compliant, my lord. Let them. If the act will be amended, my lord, everything will solve, my lord. But they stated that they have to against, my lord.
Rules are, my lords, effective enough, my lords,
in other states that has been stopped, my lord, because the act has been amended time to time, my lord. They admitted that they have to examine.
No. This what you pointed out, that first affidavit, annexure A/4.
Please, my lords.
This is all cases of even transportation, right?
Transportation, my lords. Which
not
is,
slaughter.
No,
slaughter.
which is, my lords, this petition deals with illegal cow transportation of cows, my lords.
Not slaughter.
Not slaughter. Sorry.
Oh, I see. Just transportation.
Yes, my lords.
My lord, some unreported things are there, my lord. That can I can't, my lord, state before this court, my lord. The smuggling also going on. That
the prayer
that has
at
not been
page
reported.
18. Prayer at page 18. As to why the prohibition of cow slaughter and its progeny and illegal cow challan in the state shall not be stopped by appointing of special task force for better implementation.
No. So it's cow slaughter and so how many issues have we got? Any instances of cow slaughter in the state?
Each and every day that is happening, my lord, but that has not reported.
Can't simply say that, sir.
That is
what is
that? That's
how many such instances of cow slaughter is happening? These cases that you have listed out, some 21 cases, how many of these are actually cow slaughter cases? How much of it is transportation cases?
That has been downloaded from the net, my lord.
But you are not clear, sir. Unless there's some homework somebody has to do, sir. Otherwise, we have to rely only on the state, whatever the state says.
State to direction, all
right. Say annexure A4 to the counter affidavit filed by the state.
All the cases, my lord, class order ballot act is mentioned, my lord.
Gives a chart.
Section 7 of
is a chart of the total number of cases registered under the. This is under the Orissa Act or the Central Act? Under the Orissa Prevention of Cow Slaughter Act 1960.
And the rules.
And the Orissa Prevention of Cow Slaughter Rules 1966 from 2017 onwards. Full stop. It shows that in 2020, there were 267 cases registered in all throughout this state. And in 2021, 371 cases were registered. So it is, however, not clear whether these cases pertain to instances of single course cow slaughter or illegal transportation of animals. So in other words, the breakup is not given of what are the types of cases that these pertain to. So in the rejoinder filed by the petitioner, details of 29 cases.
All the cases, section 7 of the class order act is mentioned, my lord. All the cases. Page 20, page 11, my lord. Keonjhar PS case on 35 to 21.
Details 29 cases have been
11 prevention of cruelty to animal and section 7 of the Orissa Prevention of Caste Slaughter Act.
Correct. 18 of the
most of the
rejoinder
cases.
affidavit. These are spread over from 2019 to 2021. However, here again, it is not clear how many of these cases pertain to actual instances of cow slaughter and how many to instances of illegal transportation of animals. Paragraph. These particulars would be relevant considering the main prayer in the writ petition that there should be a special task force for implementation of the provisions of the above act. Paragraph. As far as the prayer of the other prayer of the petitioner, that the Odisha Act should be amended in line with the acts in other states concerned. It is stated in the affidavit dated 12th December 2022 of the state government that this aspect is being examined. Paragraph. A further affidavit on the above aspects be filed by the state not later than 1st July 2023. List on 2nd August.
Great.
We have put 7 and 8. Limited rule. 7.
All right.
Item number 60.
May I please, Your Lordship? The petitioner has moved this honorable court, calling it question the input notification dated 8/4/22 on Annexure 3, and he has also prayed for quashing of Annexure 5 notification. Under Annexure 3, the opposite party number 3 has taken steps for making formation of the committees functioning under the council in gross violation of the provisions of Orissa Higher Secondary Education Act and rules. There is gross violation that is very much apparent from documents. I will take Your Lordship through different documents. Your Lordship may kindly turn to Annexure 1.
That is for the council here. He has served me a copy on 3rd of January. On 3rd of January, he has served me a copy. I am appearing with the Council of Higher Secondary Education. Lord, and I can be given some time to file a counter affidavit for Your Lordship, because he is challenging a committee. Of course, this person is a stranger.
No, it is not a stranger.
And also,
there is a gross violation
in
of
the shape of a PIL without giving any prior notice as required under Rule 8, not giving any prior notice. So it's not in the also proper form. As if a person aggrieved has filed, it's a PIL, not connected. He is not.
Just come to the prayer.
Your Lordship may kindly have a glance to my prayer portion. In the prayer portion, I have prayed for quashing of a notification date of OP number 2 dated on Annexure 3 of the writ petition, along with his consequential notification dated 28/4/22 under Annexure 5. That is table 3 lekha. And the text steps for making notification afresh for nominations of members of different committees of council of higher secondary education Odisha by way of election on receipt of names of 5 headmasters of higher secondary schools from the OP number 1 in terms of provision so and so, and taking into consideration the names of MLA nominated by the opinion of 1 to be the members of council by its letter dated 9/5/22 on Annexure 6, Miller. The problem is after constitution of the committee council under Annexure 1, your lords may see, since it was not full-fledged, the opinion number 2 under Annexure 2, your lords may turn to Annexure 2, page 17, made a move to opinion number 1 government, seeking nomination of 5 headmasters and 3 MLAs to be the members of the council, and that is Annexure 2. You also may see that document clearly shows, and that is written to the government. Opinion number 1, in inviting reference to subject cited above, I am to bring to your kind notice that the name of the members under the following heads have not been nominated by the government towards formation of the council members as per the Orissa Gazette notification dated 17/2/21, and also as per the Act and Regulation 92. 5 headmasters higher secondary schools to the extent available in terms of 3B IV. Thereafter, 3 members of Orissa Legislative Assembly to be elected from among themselves in terms of Rule 361. Before giving a response to that, under Annexure 3, the opinion number 2, without waiting for the nomination of 5 headmasters and 3 MLAs, who are to be the members of the council as per the nomination of the government. Government has not sent their names. And before that, the opinion number 2 under Annexure 3 made a move to make a nomination of to fill up the vacancies of the council of the different committees of the council. Under Section 21, there are different committees functioning under the council. The council functions through different committees. And those people, 5 headmasters and 3 MLAs, who are to be elected by the government, nominated by government, they are to be the members of the council. Thereafter, process of nomination should have been started so that they could have participated in the process. They could have also become the members of the committee. But before receiving any response from the government under pursuant to Annexure 2, this opinion number 2 in gross violation of the provisions under Annexure 3 made a move to fill up the vacancies of the council, of different committees under the council. And that challenge, since that was a clear violation of the provision, and the council is getting affected, and the council is looking after the examination and of higher secondary study of the entire state. It is a statutory body. It should be properly constituted in terms of the provisions of rules which are holding the field.
All right. You see at the outset, the court corrects the typographical error in its order dated 28 November 2022, where instead of IA number 6079 of 2022, it should be IA number 14131 of 2022. The order should stand corrected accordingly. Paragraph. And in the main writ petition now 11628 of 2022, the main grievance of the petitioner concerns the proper constitution of the Council for Higher Secondary Education, bracket CHSE, bracket, in the state of Odisha. Full stop. According to the petitioner, as presently constituted, CHSE does not have the 3 MLAs nominated by OP number 1, and more importantly, 5 headmasters of higher secondary schools, as required by Section 3, small b, small 4 of the OHSC Act 1982. And Section 3, bracket C, bracket I, thereof. Paragraph. Notice.
I'll accept notice on behalf of the council, man. Council of Higher Secondary.
I am for the 1, my lord. All right. He's for 1. Mr. P.K. Ratha for 2. Replies be filed within 8 weeks, rejoinder for the next date. You put down 11628 of 22 along with this 6079 of 22. Just say notice, he accepts notice. Reply with.
I have filed and I also prepared.
That's right. We have issued notice on that also.
All right. Okay.
I'm requesting a copy of the consolidated writ petition.
Yes. Copies of the consolidated writ petition be served on both of them. list on 6th July.
Item number 61.
61, my lord. I need some time for preparation.
All right. Council of the state needs time to prepare his submissions. The interim orders have worked itself out, right?
It is working even today, my lord. Interim order to continue, my lord.
All right. You just say MC number 5761 of 2008. The interim order passed by this court on May 2008, which will continue during the pendency of the writ petition. This miscellaneous case is disposed of. In the main writ petition, you see list on 13th July.
Item number 62. The reassessment order was challenged in appeal. And during pendency of the appeal, there was a direction to deposit. I came up before your lordship in all these three writ petitions. Your lordships had protected to the extent the demand, and rest your lordship said that the bank account can be operated. Now I have succeeded in appeal.
So this
And the
is infractuous.
Your lordship may kindly indicate that I have succeeded in appeal. The assessment orders have been set aside.
All right. Mr. Ramakanta Mahanti, the senior counsel, informs the court that the appeals filed by the petitioner SSC have been allowed, and the assessment orders in question have been set aside. So therefore, these writ petitions have become infractuous and are accordingly disposed of.
Interim order is
the
vacated.
interim orders stand vacated, right?
Item number 63.
63 minor not press.
Not
63, 70, 71, 72.
63, 71.
63 not pressed.
63 not pressed.
63 mine.
Maybe you're talking a weekly list, sir. It must be the weekly list.
Supplemental
Mr. Patnaik's case is 63.
All right. Yes, sir.
In 63, my lord. I will prepare a short note. Entire case of the department, my lord. They have already averred at a paragraph 7 of their counter. Paragraph 7 of their counter, madam. There is no provision to rectify the mistake committed in GSTR 1 for financial 17-18 after due date of filing GSTR 1 for the month of March 2019, that is 30th April 2099, available in GSTN system, madam. That the whole grievance department not consider my application, which is pending before opposite party number 6, as because there is no loss of revenue, as already averred in my writ petition at paragraph 4.
No prayer against loss, my lord.
No, in paragraph 4, I have already averred there is loss of revenue, and to that
You are appearing, sir?
Sir, my lord, as per the instruction of department, the last date of the amendment was GST 1 was 13 April 2019 for the financial year 2017-18. There is no provision in GST Act for the amendment of GST 1 after filing of annual return. So they have already filed after a due date. So There is no provision for amendment and rectification of the GST 1.
My lord, I have already submitted an application before the office number 6 for rectification of the mistake because it is a mistake committed by me. My lord.
When? The question is, when do you come for all the correction is question. If it is relating to a period of 2017, because the period you're talking of September 2017 and March 2018.
My lord.
So when have you approached for correction is the question.
My lord, I'm approached so many times before the authority.
No, only 2020, sir. See, much after. See, 2019, the last date got crossed.
Because I'm a
You woke up, no, just in your own list of dates, come to B and C. I mean, you've typed two things as B anyway. You acknowledge that you filed the GST return on 8 July 2018.
My lord.
The last date for filing return was 31st March 2019.
My lord.
You filed the return. You've already filed the return.
I filed the return mistakenly.
Where's the question of now correcting the GST form?
So
GST R1.
And the department has given you a time for correction up to 30th April 2019. Within that period, I have not submitted my corrected returns because I am not aware of there is a mistake committed by me. I am only aware of the mistake when the government of Orissa OCC Limited has told me that your return is defective. It should be to B to B to B. But it is written B to B or B to C. So that it goes to the customer, not to the dealer. So that I am become prejudiced because my payment is held up with that department due to this reason. Because that amount has not gone to their end. There is no loss of revenue. Government has got their revenue. No loss of revenue matter. Only my return has to be that permitted to rectify my mistake. That's why there is a decision of this I have already been quoted in this in my regender, my lord. That at page 50, my lord. My regender.
No, this is not their mistake, sir. You have wrongly indicated in form. See, you filed the wrong form in B to C instead of B to B.
My lord, I do admit that I have.
It's not their mistake. So there are other matters where the portal is down, the portal does not let you file, all that is there.
They only allow
this
me
is not that kind of a case.
They only allowed me to rectify my return.
But when? After the deadline is crossed.
No loss of revenue, my lord. Department do not lose a single pay because I will suffer due to I file a wrong return. So I want to rectify the same. When there is no loss of revenue, the department has not permitted to rectify my return. That's the whole given before my lords. So man cannot be remedialist, man. But my legitimate mistake I have committed by which we have not eligible to get my dues from the OCC Limited due to wrong filing of the return.
What is wrong in there? Just see it's about the time. Just see your own list of dates.
My lord.
19 June and 23rd March.
That I admit, my lord. That I may admit.
Come to see. See, this is of GSTR 1 for FY 2017-18.
My lord. Last date is 13th April 2019. Within that period, I have not filed because I do not aware about my mistake. I am subsequently aware about my mistake.
They also do, sir.
So there is no loss of revenue. That's why the government will not cooperate.
Chemicals and
my lord, in that decision, my lord, it has clearly stated in the absence of any enabling mechanism.
No, where's the judgment?
No, one copy.
Give him a copy, give us 2 copies.
Only one, because
no, then give it back. So some procedure has to be followed.
I have only one.
I know you think us to be just High Court judges, 2 judges, 1 copy is enough.
I'm sorry.
And other side doesn't need copy. This is all your rules.
I'm sorry, my lord.
Your own rules, but for us it's difficult, sir.
I'm sorry, my lord. I've already highlighted that portion, my lord. That I'm,
let's do a proper job, sir. You want an order in your favor, correct?
My lord.
You have to work for it, sir. Simply one paragraph I will read, you pass an order in my favor means difficult.
No? I may excuse me, let us after lunch. Or
after lunch. We'll call out that first. So
Yes, Mr. Lohani is here. Mr. Secretary.
Item 57.
Lord, what has happened? I was just going through the file. There was an affidavit by the Rural Works Department that the proposal is sent to the Panchayat Raj Department. That is Annexure F/4. But there was no there is no request. The Annexure F/4, if your lordship will see, it is requested that appropriate step may kindly be taken to declare the roads, to improve the roads for better communication. So this is the matter for which your lordship has directed to seek instruction. What is the status of this? And the secretary, I was supposed to file the affidavit today, but we require only 1 week time because the reason my secretary will convey to your lordship may ask him, he is there.
Yes, Mr. Lohan.
Good afternoon, sir. Sir, actually, we could not trace this proposal in our department, sir. So, kindly excuse me, sir. Within a week's time, we will take decision and communicate to the Honorable Court.
No, but what was the actual issue? When where is it? You have to hand over the road, is it?
Yes, sir. Actually, there is a road under our department, which now request is to transfer it to RD department so that they can
No, will that get done or not?
Sir, this most likely will be done, sir. I'll just need a little time to, sir, examine this proposal, sir. Kindly give me 1 week time, sir. We'll take a decision and communicate, sir.
Mr. Lohani, who is the secretary in the Panchayat Raj Department, is present in virtual mode and says that he needs 1 week's time to take a decision on the proposal submitted for transfer of the road of 5.5 kilometers from Ong Nadi Ghat at Lakhamara to Chhattisgarh border via Chandrapali, which according to the petitioners would give road connectivity to the peripheral border area of the state. Full stop. An affidavit incorporating the decision of the government in the Panchayat Raj Department be placed before the court on or before 24th January. List on 31st January.
Thank you, sir.
Mr. Lohani is requested to remain present virtually. You can come virtually, sir.
Yes, sir. Yes.
All right.
Thank you.
My lord, on that day he will come.
Yes, 31st.
We'll file the affidavit.
That's right. In case we have some questions to ask, depending on the decision.
Yes.
It's only virtual, so you can come.
Okay. Right. Thank you, sir.
Thank you.
Item 60, please.
Paragraph 20, page 7. In absence of an enabling mechanism, I am of the view that the assessee should not be prejudiced from availing credit that they are otherwise legitimately entitled to. The error committed by the petitioner is an inadvertent human error. The petitioner should not be in a position to rectify the same, particularly in the absence of an effective enabling mechanism under the statute. This repetition is allowed and the notice settles.
I think it's a reasonable approach, sir. Give him a chance. You see the court, the petitioners before this court seeking a direction to the opposite parties to permit the petitioner to rectify the GST return filed for the period September 2017 and March 2018 in form B to B, B and number 2 and then again B, instead of B to C as was wrongly filed under GSTR-1 in order to get the input tax credit benefit by Messrs. Odisha Construction Corporation Limited, the principal contractor. Paragraph. Admittedly, the last date for filing the return was 31st March 2019, and the date by which the rectification should have been carried out was
13th April to 19th.
13th April, na? 13th April 2019. Paragraph. It is the case of the petitioner that the error came to be noticed after OCC Limited held up the legitimate running bill amount of the petitioner by informing it of the above error on 21st January 2020. We'll stop. It is the case of the petitioner that thereafter it has been making requests to the opposite parties to permit it to correct the GSTR-1 forms, but to no avail. Paragraph. The stand taken by the opposite parties is that once the deadline for rectification of the form was crossed, then no further indulgence need to be granted to the petitioner. Paragraph. The fact remains that by permitting the petitioner to rectify the above error, there will be no loss whatsoever caused to the opposite parties. So it is not as if that there will be any escapement of tax. Full stop. This is only about the ITC benefit, which in any event has to inure to the petitioner. Full stop. On the contrary, if it is not permitted, then the petitioner will unnecessarily be prejudiced. Paragraph. In similar circumstances, the Madras High Court, in its order dated 6th October 2020, in writ petition 29676 of 2019, bracket Messrs. Sundike Him versus the Assistant Commissioner, accepted the plea of the petitioner and extended and directed that the petitioner should be permitted to file the corrected form paragraph. For the aforementioned reasons, the court permits the petitioner to resubmit the corrected form B2B under GSTR-1 for the aforementioned periods September 2017 and March 2018, and to enable the petitioner to do so, a direction is issued to the opposite parties to receive it manually while reflecting the change in the portal. Full stop. The directions be carried out within a period of 4 weeks. You say once the manual corrected forms are received, the department will facilitate the uploading of those details in the web portal. Right. The writ petition is disposed of.
Annexure 250 request. Annexure 250 to be set aside there.
Accordingly, you say the decisions in annexures 1 and 2.
They refused not to entertain it.
The letter of rejections dated 19 June and 23rd September 2020 are hereby set aside, and then you say. All
right. Supplementary list item 64.
May I please, my lords?
Yes.
Because in this case, the short question involved is, lords, whether in view of bar provided under section 78(4) of the Orissa Value Added Tax Act, my lords, the exercise of so much revision power by the commissioner purported under section 79(1) of the said act, my lords, against the order which is amenable to appeal, can at all be reviewed, my lords. That's the question. Your lordship have answered one. I will give a judgment of a recent judgment. So my lords may kindly now turn to, my lords, page 25. Page 25, my lords will find the first page of order of assessment, which is passed under section 42 of the Overt Act, my lords. And at the bottom, the lords may kindly see demand raised is 1,98,405. But I carried a statute of appeal under section 77 that ended with an order. And your lords may kindly see the last conclusion passed the appellate authority at page 80, my lords. Appellate order at page 80.
Yes.
My lords, last paragraph. With the observation as above, the appeal is allowed in part and the law and STO is directed to recompute the tax liability of the dealer accordingly, and excess amount, if any, paid if any, considering the excess carry forward as and so and so, payment made voluntarily for an amount of 4,18,000 so and so, and the worst contract deducted at source may be refunded as per the provisions of law. However, if there is any liability on the dealer, any tax liability, penalty as per 42(5) may be levied. Next page. In the result appeal set aside, law and STO directed to recompute the tax liability of the dealer as per observational directions made above within a period of 3 months to date of issue of order. But as the body of the appellate order, you will actually find those 3-4 issues, whatever are involved. There is clear-cut finding with a direction to either grant adjustment or to grant refund. There is nothing left to the assessing officer. The way remand orders are passed to reconsider. Here, everything is determined by the appellate authority. Only direction of recompute, because he has no choice of his own to traverse beyond the direction. Now, pursuant to this appellate direction, page 82, you also may kindly see, the order passed by the assessing officer, even if it's nomenclature as reassessment, but it's an order of recomputation. And my lords may kindly see page 93. The order of recomputation ended with a refund of excess, page 93, my lords. Thus, the excess payment of rupees 63 lakhs 80,465 is refunded to the dealer company, my lords. Thus, now, after this refund order, to circumvent grant of refund, my lords, there came annexure 4, which is a somewhat revision notice purported in 79(1). Thus, now question arises, if your lordship will go to the statute, my lords, that says, because first appellate order is amenable to appeal both at the instance of appellant as well as by the state bureaus. If they are aggrieved, they will carry forward appeal for the tribunal. If I am aggrieved, I will also. Instead of choosing to file appeal, which is appealable order, you can't go to the other route of somewhat revision. That is what your lordship, my lords, decided very recently, my lords, in the case of Sarala Project Works Limited. Now they say that what we are revising is assessment, not the appeal order.
Yeah, new notice.
the commissioner is now going to revise not the appellate order but the recomputation, reassessment order.
But that merged, that has merged.
Exactly, my lords. That is exactly. So your lordship may kindly see my lord judgment. Your paragraph 6 of your lordship judgment.
Yes.
Paragraph 6, 10 and 11. Paragraph 6, it starts, my lords. The specific interpretation of that, the very purpose for which notice order 79.4 was issued by the commissioner was already the subject matter of appeal before the JCST, and the department itself could have gone in appeal against the said order under section 70 of the OVT Act, has remained uncontroverted. In terms of 794B, read with section 79.5 of the OVT Act, there is a clear statutory bar to the commissioner exercising so much revisional power in such circumstances.
Right.
If your lordship will see 78.4, it's a clear bar. If the order is amenable to appeal, he could not have exercised so much revisional power. That is what has done in this case.
Right.
Here the fact is different. The issue here, whether the return was scrutinized by the assessing authority or not, that has been in the scrutiny. The Joint Commissioner has detected.
No appeal effect has been given. He's recomputed. You've accepted. See, once you've recomputed, found nil tax liability, where's the question of again reopening all this? You can't go on visiting it again and again.
Question is, after assessing authority giving effect to the appellate order, what order are you revising so much?
The assessment.
Where is the order? Is it an assessment order? He has complied with the appellate order. At best, you could have done that appellate order, not the.
Is that correct?
That liberty may be given, my lord.
No, why? You have to bring everything to a close. Sometime it has to end. Can't go on and on.
Merely because the refund flowed.
That's all. That's
maybe, my lord.
That's the only reason. That's the psychology. The man thinks he's going out of his pocket. He should somehow prevent it.
Revenues interest, my lord.
The challenge in the present petition is to a show cause notice dated 10th May 2022, issued by the Joint Commissioner of Sales Tax, Territorial Range, Cuttack. To the petitioner. Under section 79 bracket 1 of the Orissa Value Added Tax Act 2004 bracket OVAT Act, on the basis that the order passed by the sales tax officer bracket STO, Jagat Singhpur Paradeep on 30th March 2021 under section 42 of the OVAT Act for the tax period 1st April 2009 to 31st March 2014 was erroneous and prejudicial to the interests of the revenue. Paragraph. The background facts are that the petitioner is engaged in the business of works contract and is registered under the OVAT Act. Audit assessment proceedings under section 42 of the OVAT Act were initiated against the petitioner for the aforementioned period on the basis of an audit visit report, bracket AVR. Stop. The assessing authority, after going through the books of accounts produced by the SSC, raised a demand of 114,11,234, allowing input tax credit bracket ITC of rupees 10,16,463, thus requiring the petitioner to pay 103,94,771, and also penalty of 67,98,937 under section 42 bracket 5 of the OVAT Act. Paragraph. The petitioner then filed an appeal which came to be allowed in part by an order dated 19th April 2018 of the Additional Commissioner of Commercial Taxes bracket appeals. Full stop. The operative portion of the said order reads as under: take from bottom of page 80 with the observation as above, the appeal is allowed in part, all that. The STO is directed to, open quotation, recompute the tax liability of the dealer as per observation and direction made above within a period of 3 months from the date of receipt of this order. Full stop, unquote. Paragraph. Pursuant to the above order, the assessing authority recomputed the tax and passed an order on 30th March 2021, which resulted in a refund of rupees 63,80,465. Stop. In other words, appeal effect was given to the order of the first appellate authority, resulting in a refund to the petitioner. Paragraph. More than a year later, the impugn notice has been issued on 10th May 2022 by the Joint Commissioner of Sales Tax, seeking to reopen the very same assessment. Full stop. Once the remedy of filing a further appeal by the department against the order of the first appellate authority as provided
78 ballots.
78 under section 78 was not availed, and in fact appeal effect was given to that order by the department. The question of invoking section 79 bracket 1 of the OVAT Act did not arise. Full stop. In fact, there is a specific bar to such exercise of revisional jurisdiction under section 79 bracket 4 bracket small b, read with section 79 bracket 5 of the OVAT Act. Full stop. Paragraph. This court, in its order dated 22nd December 2022, in petition civil 5129 of 2016 bracket Messrs. Sarala Project Works Private Limited versus Additional Commissioner of Sales Tax, Katak, has held likewise. Paragraph. For the aforementioned reasons, the impugned notice dated 10th May 2022 and all proceedings consequent thereto are hereby quashed. The writ petition is allowed, no orders is to pass.
Item number 65.
Challenge the letter dated 17/7/2013 under Annexure 5. My lord is already directed to file an appeal before the Board of Revenue, my lord. But they are here, my lord is directed to file by 2nd January.
That date may be extended.
That may be extended.
In terms of the order dated 24th November 2022, passed in court on the petition civil 26231 of 2013 bracket Messrs. Umeri Distillery Private Limited versus State of Orissa. The court permits the petitioner here to file an appeal against the impugned order dated 17th July 2013 of the Excise Commission of Orissa, Cuttack, before the Board of Revenue on or before 1st March 2023. Full stop. The delay in filing such appeal will stand condoned by virtue of this order. Full stop. The Board of Revenue will then hear the petitioner and pass an appropriate order in such appeal in accordance with law within a period of 6 months thereafter. Full stop. Till then, the interim order passed with this court on no, there is no interim order.
No interim order is there.
Take that off. The court clarifies it has not expressed any view on merits. Full stop. It is clarified that the petitioner will be permitted to urge all submissions raised in this petition before the Board of Revenue. Paragraph. The writ petition is disposed of in the above terms.
66.
My lord, item number 66, the matter has become infructuous.
All right. Dismissed as infructuous.
Item 67.
My lord, in fact, this case is covered. I have challenged the demand of MCL, demand of my lord, differential excise duty on royalty and stowing excise charges, my lord. That, my lord, that notification on the basis of which this impugned demand was issued, that was already quashed, my lord.
Oh, I see.
And this, I am praying, my lord, this annexure 1, the demand may be quashed, my lord.
All right. The court is informed that the notification on the basis of which the impugned demand was raised already stands quashed by the, that is the notification dated 21st October 2015, stands quashed by the order dated 19th February 2019, passed with this court in writ petition civil 10979 of 2016 bracket Messrs. J. Hanuman Coal Traders versus Chairman cum MD Mahanadi Coalfields Limited bracket. In that view of the matter, the impugned demand is hereby quashed.
Obligation.
The writ petition is allowed, no orders, of course. Okay.
Item 68.
68 and not present.
Dismissed as not pressed.
Item 69.
None of business.
Item number 70.
72, 72, not present.
70, 71, 72, not pressed.
Item number 73.
Lord, I request your lordship to look at the last order where the government of India, Mr. Padhi, was supposed to file an affidavit as to the applicability of the draft gazette notification requirement of obtaining EC. If affidavit is filed, kindly see order dated
27 September.
Right, 27th of September 2021.
Yes, Mr. Padhi.
Yes, my lord. We have filed a preliminary affidavit by the OP number. This environment.
And Mr. Padhi, এটা দিয়ে দেখুন এই অর্ডারটা দেখুন
The OP number 8 has filed a affidavit. Again, after this order, we didn't have any instruction, my lord. Let's make it time.
Some more time.
Yes.
Mr. Padhi seeks some more time to file the detailed affidavit in terms of the order dated 27 September 2021. So the said affidavit shall be filed positively on or before 3rd April 2023.
In the second matter, there is an interim order. Both the matters connected for one petitioner.
Rejoinder will be filed before the next date. The interim order in writ petition civil 3209 of 1919 will continue.
Grateful.
And Miss Babita Saw is appearing with you.
Yeah. It's on 1st May.
My lord, it's 1st May. Yes, obligement.
Item 74.
My lord, your lordship has directed the State Council to take instruction.
Yes.
For adjustment of the petitioner in any Anganwadi post, any Anganwadi center.
The instruction is that there is no vacant post for Anganwadi worker in Bishnupur Anganwadi Center against which the present appellant can be considered. This is for
Not Bishnupur, my lord, Bishnupur. You will also directly under the Patamre ICDS project. That has been filled up, held by that opposite respondent number. That has been held by the Bishnupur has been held by the respondent number 6. You will also therefore directed the order Patamre ICDS project in against any vacancy, take instruction if any vacancy for adjustment. My lord.
That is the specific instruction is there is no vacant post for Anganwadi worker in Bishnupur.
Bishnupur filled up by the opposite respondent 6, whose appointment I have challenged, my lord. The illegality has been committed. After being satisfied, your lordship is directed that find out the vacancy in Patamre ICDS project.
Instruction, that means it is incomplete.
Incomplete instruction, my lord, completely. Your lordship knows that respondent 6 is holding that post in.
Correct. The instructions conveyed to Mr. D.K. Mohanty is that there is no vacancy at present at the Anganwadi Center in Vishnupur, whereas respondent opposite party number 5 is already holding the post.
6
is already holding the post of Anganwadi worker bracket AWW at the said AWC. Paragraph. A further affidavit will be filed by the state indicating whether the appellant can be accommodated in any other AWC.
Under Patamre ICDS project.
Under the Patamundai ICDS
project.
All right. The affidavit will be filed not later than 1st March 2023. List on 2nd May.
75. 2nd May, he may be age bad, my lord. Therefore, your lordship fix an early date, my lord. 45 you will see.
Okay. 1st March, then you can list it on 9th March.
75.
I may plead your lordship.
In 75, right, my lord, before my lord, senior stars, there is a delay of 1,314 days.
Which
that
one?
has been condoned. That has been condoned by lordship. The same has been condoned by lordship. It is maternity pension.
Correct. Why have you not filed an affidavit so far, sir?
The state has not filed it.
No.
Let's say, look at the date chart. I am giving the date chart.
No, but will his reply not be important?
Will
the reply not be important, sir?
Let them file it.
Yes, I will file an
reply be filed by the state positively on or before 3rd April 2023. Rejoinder that if any be filed for the next date. List on 4th July.
4th July, 80 years. Picture of lordship is 80 years. Pension.
We'll have it on 8th May.
Okay.
8th May.
Item number 76.
Kindly investigate, man.
76. No, in
Why,
item
sir?
76, your lordship has directed to produce the records. I will take some more advance.
All right. Mr. Mohanty seeks more time to produce the record. Ninth May.
9th May.
77.
Item number 77, my lord. Before I begin, my lord, I was going through the file. I found the date chart has been prepared is very lopsided.
All right.
Can your lordship give me except 16th and 19th, my lord?
No, we'll have it in May, sir. Mr. Mohanty states that he will prepare the comprehensive date chart and present it before the next date. 9th May. This also. 9th May.
19th?
9th May.
May. Lord, that will be nearing the vacation. If a little bit earlier this side.
All the dates, there are a huge number of matters, sir.
Vacation oh, sorry, my lord. Before the vacation, nothing will happen, my lord. Nobody will be in a mood, my lord.
But number 3.
Except judges.
My lord?
Except the judges. 13th April. 13th April, sir.
20th April.
Your lordship,
13th April.
Your lordship, I am appearing on behalf of Mr. S. B. Jana. The name may be reflected.
All right.
For OP number 3 and 4.
All right. The name of Mr. S.P. Jena be reflected for OP's 3. All right.
Item 78.
Please, your lordship. My lord, the petitioners have challenged the order of honorable single judge dismissing the writ petition, not granting the permission from the date of making application. My lord, 3 colleges in Jajpur district, they were opened in the year academic session 93-94. All 3 colleges applied for permission under section 5 of the Odisha Education Act. The committee, my lord, directed for an inquiry. The inquiry report under Annex 1 was in favor of 2 colleges. The lordship kindly come to page 20.
No, so they were to produce the records. What happened? 24th March 2017 order.
Record is not traceable. Lordship, the fees application of Lordship, Annexure 3, the input order, Lordship, Annexure 3.
Let me complete my submission, my lord. My lord, the recommendation was that observing the fact mentioned above, I recommend to accord permission for Mahapurusha Bonamari Mahavidyalaya Saili Poda. Thereafter, no permission was granted, my lord. But the Council of Higher Secondary Education granted application for the college to temporary application for conducting the examination and for teaching of the course, my lord. That continued since 1993-94, my lord. Thereafter, my lord, that I prefer the appeal. Appeal was dismissed on the ground of limitation. Then we came before this honour court. This honour court directed for re-hearing of the appeal, my lord. In the appeal, the permission was granted under Annex 3, my lord. From that is the order dated 18/12/2000, my lord. Permission was granted. Your lordship kindly come to page 22. When the facts are narrated, in view of the above facts and circumstances, I am interested to reconsider the previous order and allow the appeal by granting permission for opening up +2 arts stream with 64 seats and 4 optional subjects like history, political science, economics, and sociology from the sessions 1999-2000, my lord. Here we find the writ petition that once we have made application from 1993-94, when permission was granted, our application from the session 1994, from that date, the permission should be granted, my lord. That was, my lord, rejected by the honorable single judge. And I cited 2 decisions, my lord.
No, come to the 7th December 2017 matter. I mean, order.
Order, my lord, yes. My lord, 9/1/2017.
No, 7/12/2017.
17/1/2000.
No, 7/12.
17/12, 18/12, my lord, that is.
No. 7/12, sir.
7/12, yes. This is the 18/12.
I think we'll give him the paper.
Well, sorry. Okay.
Have you seen it?
Yes, my lord, I filed the affidavit, my lord. I have given all the documents.
This document you've given?
Yes, I have it.
When did you file it?
My lord, affidavit I filed on and it was received as 16/1/2017. I have filed.
That is on 11/12/2007.
No, the order itself is that date. No?
I have filed, my lord. All the documents, no, I have given the affidavit, my lord. I am giving that affidavit.
On affidavit is on 11/12/2017.
11/12/2017, my lord. I have given the affidavit that permission was for the policy of the government under Annex 11. They have given special permission for conducting the examination. And I have given the documents that we have appeared, the examinations, by permission of the Council of Higher Secondary Education, my lord. I have also given the tabulation sheets and everything by open affidavit. And law has been settled by, my lord, I have annexed two judgments of this honor court. In respect of those two colleges who have applied along with me, annexure 8, my lord. Your lordship can come to page 32. That is one Buddhadev College, governing of Buddhadev College. There, this honor court held that number of cases have already been decided by this court already, where the court has held that such permission, if granted by the appellate authority, should be from the session when the application for permission was made. This is, my lord, one judgment. Second judgment is under Annexure 9, same order. These two colleges, those who have applied along with us, my lord. Appeal was dismissed thereafter in the second, the remanded after remand, my lord, that appellate authority granted permission. They came before this honor court. This honor court held that if the permission should be granted from the date they have made the application for the session. That is there, my lord, at page 32. Same, completely covered by this judgment, two judgments. And the honorable single judge, what the judgment, the honorable single judge report, that is not applicable to my case. The only question that whether an application is made for permission, and if the permission is granted by the appellate authority, whether it is to be granted from the date of making application or from the date of order by the appellate authority. It has been decided that it will be granted from the date of making application. Yes, that is the only question.
Lordship, page 22. This is the order passed. Last question. In view of the above facts and circumstances, I am interested to reconsider the previous order and allow the appeal by granting permission for opening a plot to a stream with 64 students for 4 from the session 99-2000. Then, my lord, next page, Annexure 4. Permission was granted on 15/2/2001. That has not been challenged. Thereafter, permanent recognition was granted, your lordship may see, on 21/4/2008, Annexure 7. In the year 2008. That has not been challenged. Subsequently, after 13 years of the order of the passed by the minister, that has been challenged, that they are saying that from the date they have applied. And your lordship has seen that rule of establishment of the school permission granted. Section 5 of that Odisha Education Act 1969. No private education which requires recognition shall be established except in accordance with the provision of the rules made there. Any person or person intending to establish a private education or open higher new optional subject, additional sections or infinite number of students to be admitted or introduce honors course in new subjects in a recognized private education or upgrade any such institution. Accordingly, they have made an application that at that point of time that was rejected. Subsequently, the minister considered their case and allowed them from the session 2000-2001.
So that allowing has to be from the date of the application. That's all.
Yes. No, madam, they have that has been allowed from the 2000-2001. And
but when was the application made?
Application was made earlier, but that was rejected.
No, but once in appeal it is allowed, it has to relate back, sir.
If that is allowed, why we are granting permission from the date that unless they are permitted, they cannot open an institution. Once we are permitting, they are opening an institution. This is the law.
No, from which date that the recognition should start? That's the question.
Once the permission is granted?
No, but that's contrary to the two orders he's pointing out. Come to page 32.
That has not been taken into account the Section 5 of the Education Act. Section 5 of the Education Act says, once they are granted permission, you'll assume Section 5.
Yes.
Only Section 5 application was considered, my lord, in those judgments.
My lord, once they apply, unless permission is granted, they cannot be open the institution.
Correct.
Yes, well, they have been granted permission in 2000. So from that 2000, the institution will be opened.
No, but that's begging the question, sir. Well, these judgments seem to indicate that The date of passing the order is not the date of granting.
Yes, my lord, but in
it will relate back to the date of the application.
Let me read section 5. There is no provision for granting them from the date when they have applied. But
there's no prohibition also.
But in that no private institution shall open without permission of the government. So permission was granted in 2000. But they have applied prior to that, but there is no.
And they have granted appellation, my lord. We opened the granted appellation. I have given all the documents. That policy of the government was there.
Correct, correct. All right. Correct, correct. The challenge in the present petition is to an order dated 9th January 2017, passed by the learned single judge, dismissing writ petition civil 22858 of 2012, filed by the present appellant. Paragraph. In the said writ petition civil 22858 of 2012. The prayer was for quashing the year of permission granted to the appellant by the order dated 18/12/2000 passed by the government of Orissa in appeal petition number 47 of 2000, and for a mandamus to the opposite parties to accord permission and affiliation, permission, recognition and affiliation to the appellant college from the academic session 1993-94 in place of the academic year 1999-2000. Paragraph. The background facts are that the appellant is an unaided, private, recognized educational institution defined under Section 3 small p of the Orissa Education Act 1969 (OE Act) in the district of Jajpur. Full stop. It was established on 3rd September 1993 with the academic session commencing with the first academic session being 1993-94. Full stop. Paragraph. The governing body of the college sought permission for opening a +2 arts college under Section 5 of the OE Act for the academic session 1993-94 by a letter dated 28 September 1993. Full stop. It is stated that the inspection officer by letter dated 25th September 1994 recommended permission being accorded to the appellant institution. Full stop. However, by letter dated 31st March 1995, addressed to the Director of Higher Education, the inspection officer declined to accord permission paragraph. Agreed by the above order of the Director of Higher Education, dated 31st March 1995. The appellant appealed to the Minister, Higher Education, Orissa, under Section 5(8) of the OE Act. However, the appeal was dismissed on 28th August 1996 on the ground of limitation. Paragraph. Challenging the above order, the appellant filed AJC number 15130 of 1996 in this court. Full stop. The said writ petition was dismissed as withdrawn by this court on 2nd November 2000, permitting the appellant to approach the appropriate authority. Full stop. Paragraph. The appellant then preferred another appeal before the government, challenging the order dated 31st March 1995 of the Director of Higher Education. Full stop. By an order dated 18/12/2000, the appeal is allowed and permission was granted for opening of the art stream with 64 seats and 4 optional subjects from the academic session 1999-2000. Paragraph. On the basis of the above order, the Director of Higher Education, by another order dated 15th February 2001, granted permission for establishment of the college from academic session 1999-2000. Full stop. Agreed by the grant of recognition and affiliation to the institution only from academic session 1999-2000 instead of 1993-94. Writ petition civil 22858 of 2012 was filed by the appellant, praying as noticed with the prayer as noticed hereinbefore. Paragraph. The learned single judge has, by the impugned order dated 9 January 2017, dismissed the writ petition. Holding that permission is to be construed as having been granted, open quotation, from the session from which the agency had desired to establish the educational institution. Unquote. This court has heard the submissions of Mr. Manoj Mohanty, current counsel for the petitioner, and Mr. Kuntiya, additional government advocate for the state. Paragraph. Mr. Mathi made reference inter alia to an order dated 13th April 2011, passed in writ petition civil 1718 of 2011, whereby it was clarified that the date on which the permission was granted by the appellate authority would not be the date from which the permission would become applicable, but from the date of filing of such application. Full stop. Likewise, another order was passed on 29th April 2015 with this court in writ petition civil 4064 of 2013, bracket governing body of Pallishri Women's College versus State of Orissa. Paragraph. The learned single judge in the present case does not appear to have noticed the aforementioned two orders of this court. There is nothing in section 5 Is there anything in section 5 that indicates from which date it will be granted?
No, madam. The permission granted from the date of making application.
No,
that is
there is-
application.
there is
for
no
the year academic. Your lordship kindly see.
There is no provision.
There is provision, my lord. That will come that tree. That application will dealt with, my lord.
There is no
Section 1, no private education institution which requires shall be established except in accordance with the provision of this act. This is first clause 1. The application along with section 3, the application along with the application permission shall be furnished undertaking that in the event that permission was being granted from the date of application that academic year only, it means.
There is no such
Not
provision.
for others, my lord.
No. Where does it say it will be from the date of the application? It doesn't say that.
Yes, madam.
No, but there's also no prohibition.
The prescribed authorities shall scrutinize such applications. Consider, my lord, subsection 5, your lordship, can see.
Rather, it's
The prescribed applications, authorities shall scrutinize each application, consider the application which are found complete in all respect and have been made in conformity with the act and rules made therein. Thereafter may make such inquiry as may deem necessary. He shall make a report in respect of each application which is recommended with the recommendation which shall be placed before the committee constituted in this behalf by the state government. Only that application, not any other application. The committee is satisfied that the educational needs of the local area are justified the establishment of an educational institution, that the place where the educational institution is proposed to be established is likely to best serve the educational needs of the area, that the location on educational institution is not otherwise objectionable, and that permission may be granted to any person or body person. The committee shall make an order to that effect specifying conditions to fulfill by such agency, my lord. Here, my lord, the college has already been established. And as per the guidelines
No, so
of
what
the
difference does it make? I'm just asking you.
Yes.
If today we clarify that your recognition is from 93, 94 and not 1999, 2000,
yes,
what difference will it make to you?
It will make me eligible to get the grantee aid, my lord.
For the earlier year?
Earlier. We have not received the grantee aid.
Oh.
Not
Other similar situated two colleges, my lord, they have got the
not
grantee.
recognized here.
I stand on same footing, my lord, there's same orders.
All right. While there is nothing in section 5, bracket 5, which indicates the date from which the permission or recognition granted will begin to operate. Equally, there is nothing in the such provision which prevents the authority from granting such permission from the date of making of the application. Paragraph. Indeed, if by the appellate authority, order of the appellate authority, the petitioner was granted permission, then it would relate back to the date of making of the application itself. Full stop. The court is therefore persuaded to agree with the appellant that the permission recognition granted to the appellate institution should have related back to the date of the application being made for that purpose. In which case, the relevant academic session from which the recognition stands accorded would be 1993-94 and not 1999-2000. Paragraph. To the above extent, the impugned order dated 9 January 2017 of the learned single judge is hereby set aside. And the order dated 18/12/2000 passed by the government of Orissa will be construed as granting permission to the appellant from the session 1993-94.
Accordingly, the recognition application may be modified by it.
Yeah, the recognition order.
Yes, yes, my lord.
Yeah, the order granting recognition will stand modified
My
accordingly.
recognition is under section 6. He fulfills the criteria, then recognition.
You
Not
have
section
already
5.
granted me the permanent recognition.
Subsequent events and recognition has been granted permanent. He was granted temporary. Then
No, permanent recognition I have given. Permanent
And
recognition
he
has
was
already been
granted
granted.
permanent recognition in 2006. That the LRC may say that
Then we
already
have
permanent
fulfilled all
recognition has been granted.
all the conditions.
Page 29, that is effect from 2006-7.
That is consequential.
Not on the basis of the if LRC may say page 29. Permanent recognition already granted.
From that session you have granted.
Yes, from 2006.
99 to 2000 on the basis of the my lord permission granted. As per the order of the
And if he has
director,
not
my lord.
permanent
Therefore, on
already
the basis
recognition
of
has been
that order,
granted.
if 93, 94, then the recognition application is to be granted. Application has already been granted temporary application from 93, 94. Only the recognition is to be accorded from
All
that.
right, anyway. All right. The writ petition.
Sir, I appeal for the OP3, my lord.
Of the above terms.
I appeal my candidate.
All right.
My appeal for the
Obliged, my lord.
Item 79.
No, item 17, I'm supplying the date chart. Manager. Lordship, the impugn order is our last page only, page 76. The Honorable Single Judge has only confirmed the order, impugn order. This is a matter concerning the predating of the seniority of a Sikhya Sahayak teacher, my lord. He was appointed in the year 2009 after prolonged litigation, whereas his colleagues have been appointed since 2007. Through this rate chart, I will only demonstrate that why I should be considered from 2007, not from 2009, my lord. May I place it, my lord.
You're not claiming any arrears of pay.
No, man, we are not.
Only for seniority, you're saying
Yes.
it should relate back.
Yes.
What's the problem?
My lord, in this case, my lord, in fact, my lord, he has applied in 2007.
Yes.
But by judicial interference, he got his engagement.
Not interference by the judicial orders. Don't call it interference.
My lord, I'm stand corrected, my lord.
Ah.
My lord, he got his engagement as Sikhya Sahayak in 2009, my lord.
Order was issued. Correct?
Yes, my lord.
Ah.
But my lord, the Sikhya Sahayak, the nature of this engagement of Sikhya Sahayak is a contractual employment, and it is for 1 year basis, my lord.
All right.
And subject, my lord, thereafter, my lord, there is a resolution which states that after completion of 3 years satisfactory service as a Sikhya Sahayaka, he will be converted to.
Correct, sir. So the date for the reckoning that date of completion of 3 years, which should be the date is the question.
My lord, that is the question, my lord. Because, my lord, because that for confirmation as a junior teacher, a subjective satisfaction of his employment as Sikhya Sahayaka for 3 years is required, my lord.
Right.
And he has completed 3 years in 2012, and he was appointed as junior teacher in 2012.
Because of your mistake. You see, if you had appointed him in 2007, along with others, he would not have lost 2 years.
My lord, my humble submission is, my lord, even if he had appointed in 2007, there was no, it was not automatic that after completion of 3 years, he will be engaged as junior teacher, and subjective satisfaction of the authority concern is there that he should satisfactorily completed as Shiksha Sek.
He wants to be considered as belonging to the 2007 batch. It's only for the purpose of seniority.
Yes, ma'am. My lord, his seniority will be calculated at from the time when he inducted into the cadre, and he was inducted into the cadre only in 2012, my lord. That is my submission, my lord. Because, my lord, that even if, my lord, for the sake of argument, we accept that he will be.
If you're given, even if you're because the writ petition, the first writ petition filed by him,
and if your lordship will see the
was disposed of on 28th March,
yes,
2008 itself, asking that his plea should be considered within 3 months.
3 months. If your lordship will,
so it will go back to at least 1st July 2008.
If your lordship will see the pace,
it is entirely because of your,
my lord, to that
lackadaisical approach that it couldn't be decided earlier.
But if your lordship will see the order passed in that fast writ application, 31 page 31, my lord, internal page 31.
Yes.
Sorry, running page 31.
Yes.
It is stated that first part was, my lord, his representation should be considered within 3 months. Secondly, my lord, second paragraph, it is made further clear that in case by passage of time, the select list of Khoira block has lost its validity and there are still some vacancies of Shiksha Sahayaka available to be filled up, the authority is concerned at liberty to issue fresh advertisement in the matter, and the petitioner fulfills all the eligibility criteria. He is at liberty to apply for the post with all genuine documents, and his application will be.
There were vacancies available, admittedly, so he didn't have to apply again.
My only submission is, my lord, that completion of 3 years is not automatic that he will get observed as a junior teacher, my lord. And he has been, because, my lord, he has to work for that 3 years so that, my lord, it can be assessed whether he was a good Shiksha Sahayaka or not. For that purpose,
he's not going to ask for arrears of pay. He's only saying for purposes of seniority, treat me as a 2007 batch. In effect, it may not.
My lord, your lordship may, if notional benefit.
That's not only notional.
Notional.
That's all, obviously.
Notional benefit in the
only notional, obviously.
In that case, my lord.
He's asking for that one.
Yeah, you're not asking for anything more.
My lord, in that case, one difficulty will be there, maybe, my lord, subject to your lordship's kind acceptance. Because if we'll enter into the cadre retrospectively, some other seniority will be affected. So that person should be
for his benefit, financial, pecuniary benefit only.
No,
pecuniary. Put him as the bottom of the 2007 batch. Nobody will raise objection. The ones who will be affected will be the 2007 batch.
Your lordship may direct that, my lord, notional benefit, he will be put
bottom of the 2007 batch.
No problem.
That's
as your lordship.
Correct.
As regards to my placement in the seniority, that has been decided in the Annexure 8 itself, that I will be taking over the position for the person. I am the SABC candidate, and the 2 persons who were there alongside me, they were having good marks and they were moved to the general candidate category, so that SABC position remained vacant, and I am only replacing that position. So whatever is the order, your lordship may peruse the Annexure 8. That is the final order they have only passed. Accordingly, it may be whatever may be the consequences of that order, that may be passed. Annexure 8, my lord. They have decided how my seniority will be placed, where I will be placed. It was a mistake on their part, and they have corrected that mistake. Page 33, my lord, last paragraph. In view of the above, I ordered as under. This is the collector who is making this order.
Then what is your grievance once they pass this order?
After this order was passed, then also it was not carried out. And again, I had to make one writ petition.
Oh, I see.
After that, only they gave me appointment. That appointment was in the year 2009.
This was also 2009, I thought.
This was
March 2009.
Yes. After the contempt, I was filed. I filed the contempt. Then they gave the appointment.
All right.
Then I continued.
All right. we say the present writ appeal is directed against an order dated 7/12/2017 passed by the single judge. Dismissing writ petition civil 17904 of 2015. Whereby the petitioner had questioned an order dated 11th March 2015 passed by the collector cum chairman Sarva Sikya Abhiyan Baleshwar, rejecting the prayer of the appellant to be considered as an appointee of the year 2007. Stop paragraph. At the outset, it must be noted that the aforementioned order dated 11th March 2015 was passed pursuant to the order passed by this court, by the 11th single judge of this court on 13th October 2014 in repetition 725561 of 2012, permitting the directing that the said writ petition would be treated as a representation and it should be disposed of by a reasoned order after giving an opportunity of hearing to the appellant. Paragraph. The background facts are that an advertisement was published for the engagement of Sikya Sahayak in 2006 for different districts in Odisha, including the Baleshwar district. Paragraph. In the provisional list of Sikya Sahayaks published on 20th December 2006 for the Khaira block of Soro DI circle of Baleshwar district, the appellant's name figured. However, in the revised final list published in 2007, his name did not appear. Full stop. The petitioner then filed writ petition civil 4245 2008 in this court, which was disposed of on 28 March 2008. The direction to the collector Baleshwar to dispose of the appellant's representation dated 20th December 2007 within a period of 3 months from that date. Paragraph. When the collector failed to do so, the appellant had to file contempt case 160 of 2009. After which, on 26 March 2009, the collector disposed of the appellant's representation and ordered as under, take A to A here. Paragraph. When despite the above order, the district project coordinator, Baleshwar, did not implement it and instead on 16th June 2009, asked the appellant to appear in his office. For his case to be considered on the basis of materials available on record, the appellant filed for the second time writ petition civil 11612 of 2009, challenging the said letter, dated 16 June 2009. Stop. Paragraph. On 19th November 2009, the said writ petition was disposed of by this court, directing the collector to ensure that his earlier order dated 26 March 2009 was implemented within 7 days. Full stop. It is only thereafter, on 18/12/2009, an engagement order was issued appointing the appellant as Sikya Sahayak. Full stop. Paragraph. For the third time, the appellant had to file writ petition civil 25661 of 2012 for a direction to the opposite parties to treat him as a 2007 appointee. Since the delay in his getting appointment was entirely due to the fault of the opposite parties. So that writ petition came to be disposed of on 13th October 2014 by the learned single judge, as noted here and before. Paragraph. When the petitioner's request was rejected by the order dated 11th March 2015 of the collector, a fourth writ petition, being writ petition civil 17904 of 2015, was filed, which has been dismissed by a non-reasoned order of the learned single judge in one paragraph. This court has heard the submissions of learned counsel of the parties. So it has indeed been a long, tortuous process for the appellant, just to ensure that the opposite parties act according to law. So stop. At every stage, the opposite parties have delayed implementation of this court's orders. And in fact, the delay in issuing the appellant his appointment order was also entirely due to the opposite parties. Full stop. Having figured in the provisional merit list way back on 20th December 2006, the appellant had to file a writ petition followed by a contempt petition for his engagement order, file two writ petitions and a contempt petition for the engagement order to be issued. Full stop. It must be recalled here that on 26 March 2009 itself, the appellant's representation had been accepted in toto, and he was asked to be appointed. And yet, the engagement order was issued only 9 months later, on 18/12/2009. Paragraph. The order dated 26 March 2009 correctly notes that the appellant who belongs to the SCBC category should be inserted in place of another candidate who, on merit, could occupy the vacancy in the UR category. Stop. If this order had been correctly implemented, then there would have been no difficulty as far as the appellant was considered. Paragraph. Consequently, the appellant made it clear that he is not asking for any arrears of pay, but only a notional benefit of treating him to be a 2007 appointee. Stop. In the considered view of the court, there should be no difficulty for the opposite parties to accept this simple request. Stop. Since in the 2007 batch, the appellant would be the only SCBC candidate.
There were many SCBC candidates. The other SCBC candidates, they went to the general category. So
who remained SCBC, with the others having already moved to the UR category.
Yes.
On merit. So there should be no difficulty if the appellant is asked to be placed at the bottom of the 2007 batch of appointees. We'll stop that way. the seniority of any of the others in that batch will not be affected. Full stop. Paragraph. Accordingly, while setting aside the impugned order of the single judge, as well as the order passed by the collector on 11th March 2015, this court directs that the appellant will now be placed at the bottom of the treated as a 2007 appointee and placed at the bottom of the 2007 batch in the SCBC category. Full stop. The orders giving effect to this direction be issued within a period of 4 weeks from today. The writ appeal is allowed in the above terms. No orders.
Item number 80.
Memos taken on record. Dismisses withdrawn.
I present my routine. I have the opposite batting. Item 8, I have the opposite batting.
Pastor matter item 41.
41, 41, my lord, is a 2014 examination matter. Now, earlier state council is conducting that examination. Now the government of India conducting the examination.
So it's all infructuous, sir.
Yes, ma'am.
Due to subsequent developments, the appeal has been rendered infructuous and it is disposed of as such. All right.
Oh, bless me. I'm grateful.
All right. Weekly.
Cut to the other.
Right.
Weekly list. Item number 59.
May I please, my lord?
Yes.
My here, the grievance is, though by the time the cancellation order was passed, my lord, I had already purchased the land in question. I have not been heard. This is 7A3 power under the OGLS Act has been exercised.
So the date of the sale deed is earlier to the date of...
much obliged, man. That is the position.
All right. On the short ground that the petitioner was a bona fide purchaser of the land in question by a sale deed dated 5th June 1985, by sale deed dated 22nd December 1995.
Exactly, man.
Which predates the impugned order dated 11th August 1998 of the Additional District Magistrate, Bhubaneswar. In RC number 908 of 1998, the said order is hereby set aside, since no notice was issued to the petitioner before it was passed. Paragraph. The RC number 908 of 1998 is restored to the file of the ADM Bhubaneswar, where it will be listed on 1st March 2023, on which date the petitioner will appear, along with the downloaded copy of this order. The ADM Bhubaneswar is requested to proceed with the matter afresh, and after hearing all the necessary and proper parties, to pass a reasoned order, disposing it off within a period of 4 months thereafter, till the disposal of such case by the ADM. Status quo as of today shall be maintained.
That's right.
The writ petition is disposed of later.
With your lordship's kind permission, 85, I had already given a memo infructuous.
All right. I think that must be...
Yes, I had filed a memo.
All right.
Grateful.
Item number 60. Weekly list item 60.
None appears dismissed.
Item number 61.
Item number 61, my lords, arising out of Odisha estate abolition proceeding. It was settled in my name, but subsequently so moto proceeding by Annexure 3 was initiated and the rent was determined in the paper of the temple, my lord. It's an appealable order, my lords. I may pray, my lords, may dispose of my lord's order. I will prefer an appeal within a stipulated time. My lords, be pleased to hold that, yes, limitation will be condoned and interim order of my lords is there to continue.
All right. Counsel for the appellant seeks leave to withdraw the present petition, with liberty to challenge the impugned order dated
Annex of 3 months.
17 January 2004, passed by the Tahsildar Puri.
OEA collector, Tahsildar kam OEA collector Puri.
Tahsildar kam OEA collector Puri in OEA bracket S case number 380 of 2000. If such appeal is filed not later than 1st March 2023, accompanied by an application for condition of delay, explaining the delay on account of the pendency of the present petition, will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view of the matter.
I will raise all my points.
The appellant is permitted to raise all pleas urged in the present petition and otherwise available to the appellant in accordance with law in the said appeal. Till such time the appeal is disposed of, the interim order passed with this court on 8 May 2014 will continue.
So the certified copy may be returned on
certified copies be returned, subject to being substituted, of annexures be returned, subject to be substituted with attested photocopies there.
Yes.
Weekly list item 62.
None appears dismissed.
Weekly list item 65.
May I please, Lordship? The writ petition challenging the award passed by the Labour Court. Here, Lordship, may kindly see Annexure 1, page 15. The opposite party 1 had remained unauthorizedly absent for more than 10 months, for which a charge sheet was issued on page 15, Annexure 1. I filed a legible copy that is at 15A.
What is his age now, sir?
Now his age must be...
He must have passed superannuation.
I am there for the respondent workman.
What's his age now?
Now his age is 67.
So anyway, reinstatement is out. What was ordered?
The order was to reinstate and pay 5 lakhs compensation.
Yeah, that's nothing, sir. How long did he work? Seven, 83 he joined.
83 he joined. Then for 10 years he worked, and then he was unauthorizedly absent for 10 months, for which a proceeding was initiated. And he has admitted that. In the reply to our show cause, he admitted that he was unauthorizedly absent. But he belatedly took a plea that I was mentally not well.
So anyway, 30-10-94, he was discharged. So
Yes.
he had worked for 11 years.
Yes. And at page 17, when a show cause was issued to him, he has admitted.
You've saved all this money, sir. For the interest on the money that you've saved itself will be more than 5 lakhs. The challenge with the management in the present petition is to an award dated 3rd December 2013, passed by the Central Government Industrial Tribunal, Tribunal, Bhubaneswar, in TR-ID case number 80 of 2001. Stop. The reference to the tribunal reads as under, take top of page 20, paragraph. The background facts are that the opposite party number 1, workman, joined the management on 7th August 1983 in category 2 minor D till the date of his discharge, that is 31st October 1994, on the ground of unauthorized absence. Full stop. On merits, the tribunal has noted that as far as the first issue regarding fairness of the domestic inquiry, the management was directed to lead evidence by an order dated 11th April 2003. Full stop. However, it failed to do so. Full stop. After the stay order in a writ petition filed with the management was vacated on 3rd March 2012, notice was again issued to the parties for appearance. Full stop. Despite notice, the management did not appear.
That notice was issued to the plant in which was stopped since 2003.
Anyway, it's all up to you to follow up on these things, sir. If they don't, the tribunal does not get a fresh address, what can it do? The workman, however, filed his sworn affidavit of evidence, which was also sent to the management. Full stop. None appeared on behalf of the management to cross-examine the workman, and therefore evidence was closed. Full stop. Issue number 1, therefore, came to be decided in favor of the workman. by holding that the domestic inquiry was neither fair nor proper. Full stop. Two reliefs were granted to the workmen. One was reinstatement in service with all consequential benefits. Full stop. While not awarding back wages, compensation to the extent of ₹5 lakhs was awarded. Paragraph. Admittedly, today, the workman is aged 67 years, so the question of his reinstatement does not arise. It must be noted here that while issuing notice in the present petition on 15th May 2014, the impugn award was stayed. Full stop. As a result, the workman has not even got the compensation amount of ₹5 lakhs, although he was expected to get wages under Section 17 capital B of the Industrial Disputes Act 1947. Paragraph. Considering the number of years of service put in by the workmen and the fact that the management never defended itself on merits before the tribunal, the court does not consider it appropriate to interfere with the impugn award of the Labour Court. The interim order is vacated. The writ petition is dismissed. No orders is to cause.
Item number 66. Weekly list item 66.
None appears dismissed.
Weekly list item 68.
None appears dismissed.
Item 69.
None appears dismissed.
Weekly list item 70.
Please go ahead, But in this case, the Labour Court held that the domestic inquiry is fair and proper, but due to lack of second show cause notice, it is that the proceeding is void. So I'm referring to that is 2005 Supreme Court, my lord, that has clearly stated that once the inquiry report has been communicated and he has availed the opportunity of appeal, so second show cause notice not necessary, my lord. Can I have a glance?
There is no stay here, sir, of the impugn award. What happened?
Impugn order, my lord. There was a domestic inquiry and he was found guilty, and punishment of compulsory retirement has been imposed. Against that, he challenged raised the dispute, my lord. And the Labour Court held that the domestic inquiry is fair and proper. Can I have glance to the page 12? That is issue number 4.
Just come to page 7, sir.
Page 7, my lord.
Of the award.
Yes, my lord.
On issue number 4.
Issue number 4, my lord. In this case in hand, on the issue of fairness of domestic inquiry, this tribunal has held that it is fair and proper. Consequent upon the inquiry report, the second party workman was imposed with the punishment of compulsory retirement, which due to lack of second show cause notice has been held to be bad in law and is illegal. In the aforesaid circumstances, it would have been proper to serve second show cause notice to the second party workman and to take a decision after consideration of the same. The materials on record reveals that the second party workman who was imposed with the punishment of compulsory retirement at the age of 55 years has crossed the age of superannuation, that is 58 years in the meantime. Therefore, the second show cause notice on any punishment would not serve the purpose. Therefore, taking into consideration the aforesaid facts, the first party management is directed to pay release 50% of the salary as the back wages. So second show cause notice,
No, 1 minute, sir. Just read it fully. Back wages. Just read it completely, sir.
Yes, my lord. From the date of compulsory retirement till his normal superannuation within a period of 3 months.
So only for the period from his date of compulsory retirement till his normal superannuation, you have to pay, and that too only 50%.
50%.
And there was no stay granted by this court.
No, my lord.
Have you paid?
No.
You filed this in 2014.
Because of the decision of the Supreme Court that the second show cause notice not necessary and he has availed.
Then why file this petition? If there's a Supreme Court judgment, you can do anything you like, correct? No. According to you, notwithstanding the award of the Labour Court, you can do whatever you like.
That is subject matter challenge before your lordship.
No stay granted.
no stay granted by this court.
My lord, since I have challenged that order, that is subject matter of dispute, and he has not filed any execution case.
I see. So you don't have to implement.
So because of the Supreme Court decision clearly stated that he has availed the
Then why file this writ petition itself? If you don't require a stay order according to you, right? Why file this writ petition? You just have to sit in your chamber in whichever company, you say Supreme Court judgment is there. It's okay if the labor court is awarded against me. Because of Supreme Court, I'd have to do nothing.
That is the finding of the Supreme Court, that is, he has upheld the opportunity of appeal. So second show cause notice not required at this stage. So on the basis of that judgment, the order is to be set aside.
I see. You don't have to pay nothing. Without any stay, you don't have to do anything.
But that is
that's the law.
Law of the land.
That is the law of the land, sir.
Law of the land that second show.
That is the law of the land that you file a writ petition. That is the law of the land that you file a writ petition challenging the labor court award. And when no stay is granted, the law of the land is you don't have to implement it. That's the law of the land.
Provision is there to file the execution case, but he has not remained silent. It is
very sad
of the workman.
Very sad. The problem is,
in pursuance to that,
workmen's lawyers are in this state. The workmen's lawyers are not doing what they should do. That's the tragedy, and people like you meaning your management, are sitting pretty.
That is in my favor.
There are so many awards against management in this state, which, despite no stay order being granted by the High Court, are not implemented at all, and the workmen's lawyers are not bothered. And then you have people like you advising your clients, sir, don't worry. We have filed writ petition, automatic stay.
There is a law of the Supreme Court that is clearly stated that second show cause notice not necessary.
You're repeating yourself. It's okay. You're pretending I have told you nothing. That's okay. That's your privilege.
I am relying on that Supreme Court judgment.
I know. You have to keep repeating what you have said, pretending that I have not told you anything. All right. This petition by the management challenges an order dated 12th December 2013, passed by the Industrial Tribunal, Bhubaneswar, in Industrial Dispute Case number 5 of 2009, whereby the reference regarding the validity of the termination of services of the opposite party workmen by the petitioner management with effect from 18 June 2006 was answered in favor of the workmen, holding the said termination by way of compulsory retirement to be illegal. Stop. Unfortunately, by the time the reference came to be decided by the tribunal, the workman had already superannuated, reached the age of superannuation, and therefore his reinstatement could not be ordered. Stop. The only relief granted was for the 50% of the wages payable to the workman between the age of compulsory retirement at 55 years and the normal age of retirement of 58 years. That is 50% of the wages for 3 years was awarded. Paragraph. Although this writ petition was filed on 9 July 2014, the management did not even file an application seeking stay of the impugned award. Full stop. Till date, that is 8 years later, the management has not implemented the impugned award, despite there being no stay granted of the said award. Full stop. With the amount being insignificant, and with the management not even prepared to implement the limited relief, the court sees no reason why it should grant any indulgence to the management. Paragraph. Even on merits, the court finds that the ground on which the tribunal was constrained to interfere was that the punishment of compulsory retirement was awarded without any second show cause notice to the workman. Full stop.
In other words, merely on the basis of the inquiry report, the punishment is awarded. Full stop. This was a major penalty which required the opportunity being granted to the workman to make his submission as regards punishment before it was awarded. Paragraph. Consequently, even on merits, the court is not persuaded to interfere. The writ petition is dismissed. No orders is to cause.
Item 71. Item number 71.
May I please?
May I please, Your Lordships?
You see, since the workman has not appeared before this court, a copy of this order be sent to the opposite party workman for him to take appropriate steps in accordance with law. Right.
Item 71.
Two read petitions are there. One is filed by workman and another by statement. Let's me turn in my state petition. Let's me turn to page 20, the award, annexure 3.
The man has already died, sir.
Yes. Yes, Your Lordship.
What's the relief granted to him?
Compensation of 50,000.
50,000, sir. I think we'll dismiss with costs of 2 lakhs.
Yes.
50,000 you've not paid for 10 years now.
What has happened, my
Poor man, his family is only left. Nothing is left.
Center was closed.
Whatever, sir.
DLR.
17 years of continuous service. He gets 50,000 at the end of it. Man dies waiting for implementation. This whole law is weighted against the workman, sir, completely. He gets nothing at the end of it. You see the challenge.
Some enhancement maybe.
Yeah, we'll do some enhancement. You see, we'll just award you interest, simple interest from the date of your termination. That will take care of everything. You see, there are these two writ petitions are directed against the same impugned award dated 26 December 2012, passed by the Industrial Tribunal Bhubaneswar in Industrial Dispute Case number 43 of 2011. Paragraph. The reference to the tribunal reads as under. Take from page 20 and top of 20, page 20 bottom. The workman had been working since 1st November 1990 as a peon in the related instruction center, bracket RI center, bracket Chaudhar, on a monthly salary, full stop. He was terminated from service with effect from 1st August 2007 without any disciplinary proceeding being initiated against him. Full stop. In the written statement filed by the management, it was admitted that the workman had been working since 1990 as a daily rated worker. Full stop. It was claimed that he had remained absent from duties with effect from 7th July 2007. And thereafter, the RI center itself was closed down. Full stop. In the circumstances, no termination order was passed. Full stop. Workmen who were working at the time of closure of the RI center were transferred to other offices under the Director of Technical Education and Training. Full stop. Paragraph. The tribunal disbelieved the contention that the workman had absented from duty with effect from 7 July 2007 without there being any material whatsoever to substantiate that plea of the management. So admittedly, no notice was issued to him before his being discharged, and notice pay also was not given as required under Section 25 capital F of the Industrial Disputes Act 1947, Bracket Act. Full stop. It is accordingly held that his retrenchment was illegal and the issue was answered in favor of the workman. Full stop. However, the only relief that was granted to him is to award him compensation of 50,000 since the center itself had been closed. Full stop. Paragraph. Having heard learned counsel for the parties, the court is of the view that the challenge to the impune award by the management should fail. Full stop. On merits, there is absolutely no material to enable the court to come to a conclusion different from the one reached by the tribunal. Full stop. The sad part, the unfortunate aspect of the matter is that despite there being no stay granted by this court, even the sum of rupees 50,000 has not been paid to the workman for nearly 10 years now, for over 10 years now. In the meanwhile, the workman died and his legal representatives, bracket LRC, have been brought on record. Full stop. The second writ petition is by the workman seeking enhancement of the compensation amount. Paragraph. Considering the circumstances under which the management has avoided paying a paltry sum of 50,000 for over 10 years now, the court considers it appropriate to now direct that the Director of Technical Education, that is the petitioner in writ petition civil 21021 of 2013, and the respondent in the companion writ petition 12464 of 2014 will pay the LRs of the deceased workman the aforementioned sum of rupees 50,000 together with simple interest at 6% per annum from the date of the discharge of the workman, that is August 2007 till the date of payment, which should not be later than 1st March 2023. If the payment is not made of the aforementioned sum by the said date, the management will pay further simple interest at 9% per annum on the said amount for the period of delay. Paragraph. If there's non-compliance with these directions, it will be open to the LRs of the deceased workman to seek appropriate remedies in accordance with law. Writ petition civil 21021 of 2013 is dismissed, and writ petition civil 12464 of 2014 is disposed of in the above terms.
Obliged, Your Lordship.
Item number 75.
None appears dismissed.
Item number 76.
None appears dismissed.
Item number 78.
None appears dismissed.
We are for the opposite party, my lord.
All right.
Item 79.
None appears dismissed.
Item 80.
My lord, 79 for the opposite party number 2, we are appearing for the opposite party. Our appearance may be recorded.
All right.
Item number 80.
80, my lord, with leave of your lordship. Page 24 is the impugned order. The Tahsildar resumes my leasehold land of my vendor after 20 years. By recording that, notice is not yet sufficient.
No notice to you.
No.
When did you buy?
Page 20. I purchased it, my lords, in the year 1998, after 18 years of the lease.
So how can he issue notice to you?
No, in 2000, they issued it. Your lordship sees page 24. The Tahsildar sees that this case is put up today. No notice could not be issued. Reissue for 15/1/2001. The next 15/1/2001, nothing has happened. And 14/2/2001 is the impugned order. The land is being reclaimed.
All right. On the short ground that.
And there is an order that the lessee is absent, although he was duly located.
Localized.
That is his vendor. That is his vendor, sir. Not him, his vendor.
No.
Yes.
Om Prakash Mahanti is the opposite petitioner.
No, not the petitioner. I am Subramsu Monpadi.
He didn't get notice. On the short ground that the impugned order dated 14/15. 15/2/2001 was passed by the Tahsildar Khurda in suo motu lease case number 37 of 2000 without notice to the present petitioner, who was the bona fide purchaser under a registered sale deed dated 30th December 1998 from the original lessee. The said impugned order is hereby set aside. Suo motu lease case number 37 of 2000 will stand restored to the file of the Tahsildar Khurda, where it will be listed for directions on 1st March 2023. On that date, the petitioner will appear along with a downloaded copy of this order. The Tahsildar will thereafter proceed with the matter and dispose it off within a period of 4 months in accordance with law. Till such time, the interim order passed with this court on 1st September 2014 will continue. The originals of the annexures will be returned subject to being substituted with the attested photocopies. The petition is disposed of.
Grateful, man. Weekly list item number 83.
83, Lord. Only short term, Lord, I wanted to approach the opposite party number 2, Lord. Because in the meantime, Lord, the opposite party number 2 has issued vending license and the identity card to the vendors.
You file a fresh petition for any other relief you want.
Yes, that is better.
The vending license will be issued by the opposite number 2.
So what else needs to be done?
Pardon, Lord?
So you can file a fresh petition if any other cause of action survives.
Yeah, approach the opposite party number 2 below.
All right.
Bhubaneswar Municipal Corporation.
All right. 64 street vendors functioning at the functioning as such at the Sri Loknath Vending Zone, Steward School Unit 8, Bhubaneswar. Filed the present petition way back on 28th August 2014 for directions to the opposite parties to implement the Odisha Urban Street Vendors Policy 2012 and not vacate the petitioners from the said vending zone. Paragraph. While issuing notice in the petition on 3rd September 2014, this court directed status quo to be maintained by the parties. Full stop. That order has continued till date. Full stop. None of the opposite parties, that is the government of Orissa, the Bhubaneswar Municipal Corporation, or the Bhubaneswar Development Authority, has filed any reply. Paragraph. Today, learned counsel for the petitioner has handed over an affidavit of petition number 30 on behalf of all petitioners dated 10th January 2023, placing in record copies of the trade license and vendor identity cards issued to each of the petitioners during the pendency of the writ petition. Paragraph. In that view of the matter, learned counsel, the petitioner states that the petitioners will again approach the BMC,
Bhubaneswar Municipal Corporation,
for appropriate directions as and when any fresh cause of action arises. The writ petition is disposed of in the above terms.
Weekly list item 84.
My lord. The workman before my lords, whose 33C2 petition has been rejected on the ground that he has given the statement of claim year-wise basis, not on month-wise basis. You are only lordship kind of gone to para 4 of the order, my lord, full order. Para 5, my lord. Para 5 at page 41. The A11 in his affidavit evidence has fully corroborated the facts stated in his claim application, in his Form T3 application, along with the annexures. He has given calculation which is amounting to rupees 1,34,000, but in his affidavit evidence, he has not uttered a single word to that effect. On perusal of the calculation sheet, it appears that the particulars given in the annexures year-wise are not clear and not month-wise. On this ground, it stated that on the other hand, the OP11 in his affidavit evidence has stated that the applicant, as per the award, has already received his pay and other allowances as per his entitlement, and he cannot agitate the matter again before the court under section 33C2 of the Industrial Disputes Act for adjudication. Peruse the award under the...
No, but their stand seems to be that you were already made...
As per Annexure 9, there has been a settlement between the management and workers' union. My claim is within that settlement, so it doesn't require any further adjudication.
No.
So if my lords remand the matter, he can give his month-wise statement.
No. Did they produce any proof of making payment to you?
Payment as per the award, he was reinstated. He was terminated, and after the award, he was reinstated.
No, sir, the management told the labor court that they've already paid you the amount.
Paid as per the award, that is back wages. But after reinstatement, he has not been paid as per the terms of the settlement reached between the management and the workers' union, that is Annexure 9, my lord. So my claim is within the framework of that settlement as per Annexure 9. Nothing beyond that. It doesn't require any adjudication, my lord. Only defect is that I have given year-wise calculation. So court wanted that he should have given month-wise statement. If my lord remanded the matter, he can get his legitimate giving month-wise claims.
That notice to opposite party number 1 was returned with the remarks unknown. What does that mean?
One regional person.
Who's the opposite party number 1? Regional Personal Manager, Peerless General Finance. Calcutta. Branch manager.
Branch here. One branch is functioning at Cuttack.
What about opposite party number 2? Has it been served? Oh, I see. Okay. Although a memo of appearance was filed on behalf of opposite parties 1 and 2 way back on 14 January 2015, today none appears on their behalf. Paragraph. The challenge by the workmen in the present petition is to an order passed by the Labour Court, Bhubaneswar, in industrial dispute miss case number 5 of 1996, which had been filed by the workmen under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket Act, claiming a total sum of rupees 1,34,503.38 consequent upon a memorandum of settlement between the management and employees union, bracket annexure 9, paragraph. The Labour Court appears to have rejected the plea of the workmen only on the basis of the claim statement not giving the figures month-wise, but year-wise. Stop. Also, the Labour Court appears to have accepted the plea of the management that the workman had already received, open quotation, his pay and other allowances as per his entitlement, unquote. Whereas according to the workman, his claim was consequent upon the settlement between the management and the union. And according to him, for the period from 31st May 1988 till 31st December 1995, he had not received any payment whatsoever. Paragraph. Indeed, it appears to the court that if the workman did not submit his calculation month-wise, he could have easily been given an opportunity to do so, instead of rejecting his claim altogether. We'll stop further. The management should have been asked to substantiate its plea of payments having already made to the workman. Full stop. For some reason, this was not insisted upon. Full stop. Paragraph. For the aforementioned reasons, the impugned order dated 28/2/2012 of the Labour Court is hereby set aside. And industrial dispute miss case number 5 of 1996 is remanded to the Labour Court, where it will be listed for directions on 9th March 2023, on which date the petitioner will appear through an authorized through his counsel. Stop. A copy of this order be delivered to the presiding officer of the Labour Court, Bhubaneswar, forthwith, through a special messenger. Full stop. The writ petition is disposed of. The Labour Court is requested to proceed with the said case and dispose it off within a period of 4 months from that date. The petition is disposed of.
Weekly list item number 87.
None appears dismissed.
Weekly list item 88.
None appears dismissed.
Item number 89.
None appears dismissed.
Item number 90.
May I please, Your Lordship?
Yes.
Here in this case, Miller, the case land is a leasehold land, Miller. And originally in the year 1965, it was leased out in favor of the vendor of the present petitioner, Miller. The present petitioner is an old lady, Miller. And that was leased out on the ground that he was an ex-army personnel, the vendor of the petitioner, Miller. Then that vendor of the petitioner, with due permission under the local act, that is OLR Act under 6(1), Miller, section 6(1), I have annexed that permission under annexure 1. Your Lordship may kindly appreciate it. That permission was accorded in the year 1980 in favor of the vendor of the present petitioner to sell out that land in favor of the petitioner, Miller. Then thereafter, the registered sale deed under annexure 2, Miller, it was executed in the very same year, in the year 1980, Miller. Thereafter, mutation was done in favor of the petitioner by the concerned revenue authorities under annexure 3, Miller. Thereafter, settlement proceeding was initiated in the Bhubaneswar, that area. Now it is come under the Bhubaneswar, but by the time of
allocation of that land under lease Miller, it was Throny Bushes Miller. And that settlement parcha, it was issued in favor of the petitioner. Your Lordship may kindly appreciate Annexure 4 Miller. Then Annexure 4 Miller, that is at page 24-25 Miller, running page of your Lordship brief Miller. Miller, my name Pavitra Das, it is written in Odia Miller, that is petitioner Miller. Miller, that parcha, it had been issued under section 12 of the local act.
Covered by that Narottam Ratham Act.
Yes, Miller, that is the decision. You Lordship may kindly appreciate Miller. That is the Miller,
because again, the seats of suo motu passed the order.
Yes, Miller, without any notice behind the back, Miller.
All right. Then just pass that on. In Miller decision in Narottam Ratham, the impugn order of the ASO is hereby set aside. And those two directives.
I have supplied the Sanatan Kumar Sahu case, Miller. That is also a
recent order.
Recent order. Okay.
This is better. This is that older order. We have referred to all this in that order.
Yes, obliged.
All right. And those two directions are issued. Right. Same order. All right. Yes.
Item number 95.
Yeah.
91.
Yes. Parties have not appeared, but I pray that let the matter be called on after 4 weeks someday. There are some mistakes I think I have to carry out with your Lordship's brief.
95.
I'll verify whether there are some mistakes or not. If so, I will make necessary correction. And here the notice has been issued long back, but the opposite parties have not appeared. And question of the counter also doesn't arise.
Do they have copies, Mr. Monty? You have copies of the petition?
The relief is claimed against OP number 3.
95.
That OIIDC.
My lord.
Who's the standing counsel for that?
95, we are not parties. Comment is not.
I pray that let it matter be called on after 4 weeks.
No, let it be fresh notice go, sir, because nobody's appearing.
Fresh
you
notice?
say notice was issued in the present petition way back on 28/10/2014.
My lord. There are
But
people
it's not
listed on
clear
1512.
if it has been served on the contesting opposite parties, that is Orissa Industrial Infrastructure Development Corporation, Bolangiri Division, and the estate officer of IIDCO. OIIDC, sorry. Stop. Fresh notice is directly issued to the opposite parties by speed post returnable on 1st March 2023, including the regular list, interim orders to continue.
I am permitted to make necessary correction if necessary.
That you file an application, sir. File an application. All right.
I'll file.
So one matter left.
Interim order to continue.
Interim order to continue.
Item number 92. Weekly at 92.
None appears dismissed.
Weekly list item number 96.
That interim order vacated, you have to say.
Your Lordship, on behalf of Mr. S.B. Jana, for opposite party number 2 to 4,
all right.
the name may be recorded.
All right. None appears for the petition. Dismissed.
Item number 97.
None appears dismissed.
I am for the opposite party.
He's for the opposite party. All right.
Yes, I am for the petitioner. I am on VC. My lord, this is the order of the RDC, thereby rejecting my application for enumeration of separate family getting the benefit of RR policy is the subject matter of this writ application. Your Lordships kindly have a glance to page, kindly see the page 47, annexure 8, my lord. After 4 paragraphs, it has been indicated so far as petitioner is concerned, as regards treating the case of Tuna Bhoi as a separate family, his school living certificate produced by his advocate was verified And as per his date of birth mentioned in the certificate, he was minor on the cut-off date, that is 1/1/2009, as he was a minor. Your Lordships kindly have a glance to the school living certificate annexure 9 at page 49. It has been indicated at 10/4/1991, my lord. Then your Lordships kindly have a glance to the annexure 10, page 50, clause 2, my lord. Date of publication of notification under section 4(1) of the LA Act will be treated as reference date, my lord. Then LA Act has been came to force that on 7/9/2009, annexure 4, your Lordships kindly have a glance. Page 31 and 32. Odisha Gazette notification has came to force on 7/9/2009. So it will consider the date of birth as a 10/4/1991. So by the date of notification, he was a major, my lord. 18 years some odd, my lord.
No. Date of section 4 is what?
Notification of section 4, my lord. Your Lordships kindly have a glance to
2009. And his date of birth is?
Date of birth is as per 10/4/1991, my lord. 10/4/1991. And the resolution indicates that the date of publication of notification under section 4(1) of the LA Act will be treated as reference date. So this was came to force on 7/9, my lord. 7/9 it has come to force, my lord. 7/9/2009. So if at all you treat this 7/9/2009 as a reference date, then he was a major, my lord, by that time. So rejection of the RDC indicating that he was a minor is not sustainable, my lord. 4(1) notification was made on 7/9/2009.
The cutoff date. That's the problem. Seems to be the cutoff date.
Cutoff date is 1/1/91.
No, that's what the cutoff date had to be the date of the section 4 notification.
The Lordships kindly have a glance to annexure 10 at page 50.
No, date of birth is.
No, cut-off date, reference date has been indicated.
My lord, page 40.
Date of publication
admission in that school.
Of 4(1).
That's okay. He must have been admitted to that school only to the answer.
But in the improved order, my lord, annexure 8, I was very much party before the RDC because I am the company.
Right.
He never hired me as a party.
Right.
I have filed intervention application, it's also there.
Right.
Item number 162 also same lawyer, my lord.
Right.
The same input order, common input order.
Right.
In the fact remains in this case, my lord. In the year 2006, the village Basudharpur came under acquisition. The villagers near about 160 acres of land was acquired in 2006. The villagers came and approached to the authority, RDC, collector and the government officials that a balance of 33 acres of land may be acquired because we cannot stay here. We will go to the RR colony. We will avail the RR benefit. Pending again this second phase land acquisition notification 4(1) was published in the year 2009 as claimed in this case. Pending this land acquisition process of 33 acres of land where the present claim lay, the villagers started shifting to the RR colony. Pending the finalization, all my counters, everything mentioned in 162 item, the same lawyer, the same input order, common. Here as because no party was made to me because I have filed the intervention application, I have not filed any counter affidavit. 4(1) section notification so far as compensation is concerned, not for RR benefit. In the RR benefit 2006, my lord, rehabilitation application that annexed, that is also mentioned. 4(1) is concerned so far as the act regarding compensation. But so far as displacement, a person who will displace from one place to another place physically,
then he will be calculated as PDF. He is not the awardee. Awardee is the grandfather.
Just come to page 50.
Page 55.
No, 50. 50.
Page 50. That is a relied irrigation project. It is not applicable. Because in RR policy, that is mentioned everything, my lord. 2006. This is for the year 1990. The RR policy 2006 is applicable.
Where is that? Where is that?
That is here the annex.
Where is that? Where is that RR
That
policy?
is annex. Your lordship may kindly come to the page 14. The Gazette Note RR policy 2006. Your lordship may kindly see the cutoff date, clause number 3, C, in the page 15.
C along with note.
Note. Cutoff date. For the purpose of compensation shall be the date on which the notification deciding the intention to acquire land under the relevant act or under the provision of the policy is published. No date is published in the policy. Thereafter, the note your lordship may kindly see in the same. For the purpose of declaring eligibility for RR benefit, the list of displaced family will be updated on the 1st January of the year in which physically displacement is scheduled to take place, provided that those families who move into the project area after determination of the cutoff date will not be eligible for any benefit. Here in this case, cutoff date was fixed 1/9, the cutoff date for all.
1/1/2009.
1/1/2009. And because on the request of the villager, 33 acres of balance land was acquired in the second phase. Pending the land acquisition proceeding, the villagers opted that they will shift to the RR colony, and all were shifted. Started from in 2008, they given option, the villager, that 33 acres land may be acquired. We cannot stay here. Thereafter, the pending acquisition, villagers started shifting and all RR benefits released. Here, the mother of the petitioner got as a PDA person, but he is a minor as per the cutoff date. 1/1/2009. Now that the RDC also dealt this matter, I have also appeared. I filed my written objection, and the entire counter affidavit will be available. Details, facts, I have mentioned item number 162. That was in that case, the RR benefit is ready and extended to that petitioner. He is not accepting, but he has filed the writ application. Here, he was declined because by the cutoff date, he was a minor.
That is a separate issue that will be decided.
In 162, he's been granted the benefit. In 162.
Yes, 162, the same RDC granted. We have also extended all the benefits.
Why is he challenged?
Till that, they have not extended, my lord. They are biasing the court. They have not extended. I am ready and
My
willing
counter
to
is there.
accept that.
I have annexed the documents. My counter is there. My counter is there, my lord. In item number 162, my counter is there. Here I am not made a RA as a party, no counter. I have filed the intervention application. My intervention application may be allowed. I will file all the details fact of counter because my counter details is available in item number 162. Similar, common input order. In that case and this case also. The London RDC also allowed in that case that he is entitled in item number 162, and we have also extended all the benefits.
My lord, accepting the argument, my lord, for the sake of argument, if I will consider as 1/1/9, petitioner is 17 years, 9 months, my lord.
I know. My lord, that annexure page 50 is not applicable. Where there is a specific RR policy was prepared by the cabinet and it was extended to all. Cut-off date was for all, not for this present petitioner. And in that case, it was allowed. In other case, also allowed, and the same cut-off date. He cannot claim another cut-off date.
There is a clear finding of the RDC at page 47.
Without
as regards
considering
treating the
anything,
case of Punna Bhoi as a separate family, his school living certificate produced by his advocate was verified, and as per his date of birth mentioned in the certificate, he was a minor on the cut-off date.
3 months. 3 months.
3 months less.
All right. You see, this is the second round of litigation as far as the present petition is concerned. His main prayer is that he should be considered as a separate family unit for the purposes of resettlement and rehabilitation as a displaced person following the acquisition of land in Basudevpur for the purposes of Jindal Steel and Power Energy Limited in Angul district. We'll stop. Earlier, this writ petitioner had filed writ petition civil 2751 of 2014, which was disposed of on 24th June 2014, directing the Revenue Divisional Commissioner, RDC, Northern Division, Sambalpur, to dispose of the petitioner's representation and pass a reasoned order. Full stop. The RDC has since passed the impugned order dated 13th August 2014, declining relief to the petitioner. Paragraph. Counsel for the petitioner submits that the admitted date of birth of the petitioner as per the transfer certificate issued to him by the school in which he studied is 10th April 1991. Full stop. He refers to a circular dated 21st August 1990 issued by the Department of Irrigation, according to which the relevant date for determining rehabilitation benefits would be the date of the notification under Section 4, Bracket 1 of the Land Acquisition Act 1894, Bracket LA Act. Full stop. According to counsel of the petitioner, since the Section 4, Bracket 1 LA Act notification is dated
One notification is 7/7/2009.
7 September 2009, going by that date, the petitioner would be a major and therefore would be entitled to be considered as a separate family unit for the purposes of the R&R policy of 2006. Paragraph. Counsel for the intervener in Miss Case number 10887 of 2015, that is Jindal Steel and Power Limited, points out that the circular dated 21st August 1990 is by the Irrigation Department and is not applicable as far as the present project of the company is concerned. Full stop. What is relevant in the present case is the Orissa Relief and Rehabilitation Policy 2006. Resettlement Rehabilitation Policy 2006. Full stop. Para 3 bracket C of the said policy defines cutoff date and reads as under, take from bottom of page 15 and top of page 16. Paragraph. It is submitted that in the present case, a uniform cutoff date declared was 1/1/2009. And as of that date, the petitioner was less than 18 years by 3 months. Paragraph. The above facts are not able to be disputed by counsel of the petitioner. Full stop. He submits that since the petitioner was short of the age of majority just by 3 months, a lenient view should be taken of the matter. Paragraph. Once it is clear that it is the 2006 policy that applies, the cutoff date would have to be in terms of that policy, which in the present case is 1/1/2009. Full stop. Going by the date of birth of the petitioner, as disclosed by him, he would not have completed 18 years as of 1/1/2009. Full stop. This is the reason that weighed with the RDC in rejecting his claim. Paragraph. The court is accordingly unable to find any error having been committed with the RDC in the impugned order. There is no merit in the present petition. It is dismissed as such. So that item 162, we'll deal with it when we call it. Yes. Let it remain. All right.